Good morning, I'm Judge Clark, and we are here for felony violation of probation and miscellaneous hearings. Ms. Merrifield, you're first on the list.
Just last I saw it, she was talking more time.
Oh, okay. Mr. Cotton.
We may be downstairs, Your Honor.
All right, Ms. Reed.
Okay. Good morning, Judge. How are you?
Good morning.
I have Joseph Matthew Diallo, and that is
25 CF 593.
593, yes. 2025 CF 593, yes, Your Honor. I did file reciprocal discovery yesterday. My client was able to get his hardship license. I believe now that he has his hardship license, we are going to be able to resolve the misdemeanor, which is the basis of this VOP. I talked to Mr. Ferris this morning. He has no objection to pushing it out one more time for us to get the misdemeanor resolved, so that we can know what we will do up here in the circuit court for the VOP.
All right. Any objection?
No, Your Honor.
All right. So this would be May 19th at 9 o'clock.
Okay.
And do you think that
Judge,
would
I think
be-
we'll have a resolution. I believe that Mr. D. Olive's misdemeanor court is prior to the 19th, and I will, actually, when I get back to the office this morning, I'll be reaching out to the county court prosecutor, and hopefully we can get the misdemeanor resolved, and if we get it resolved in a certain way, I believe that Mr. Ferris and I will be able to work something out.
Okay.
Prior to the 19th.
All right. So we'll see you on May 19th unless I see you before then.
Okay.
Thank you.
All right, thank you. That's all I have, Your Honor. May I be excused?
Yes.
Okay, thank you. Y'all have a great day.
Thank you. You too.
Thanks. If I see any lawyers out in the hallway, I'll let them know that you've taken the bench.
Thank you. Do I have Ms. Merrifield or Mr. Cotton? All right, Mr. Lupella?
I need a few minutes, Your Honor.
Okay.
Thank you. Your Honor, I can take one real quick out of custody.
Okay.
It's going to be Jenny Mirabando.
Could you spell that last name for me? Oh, got it. Irovando, case 2018, CF 310, and first name Jenny with a G, and she is present.
Yes, Your Honor.
Your Honor, the state is going to dismiss the violation of probation and allow the costs to go to collections.
Yes, Your Honor. We would ask for 12 months to have those paid. Ms. Mirabando is currently on disability, but she is working. So if the court does give her a bit of time, she should have those paid versus going to collections right now.
How long did you ask for?
12 months.
All right. Any objection from the state?
No, Your Honor.
All right. So the state has dismissed the violation, which was basically court costs, and we will allow Ms. Irvando to go ahead and terminate probation, and the costs will go to collections if they have not been paid within 12 months of today.
Yes, Your Honor.
Ma'am, once they go to collections, that's going to suspend your driver's license. Thank you.
All right. That's it for everyone. Good luck.
All right. Do I have Mr. Cruz present?
Yes, Your Honor.
Come on up. And the case is William Milano, 2018 CF 78.
Yes, Your Honor. Good morning. Tyrese
morning.
Cruz appearing on behalf of Mr. Milano.
Good morning, and he'll be out momentarily.
Yes, Your Honor. If we may just pass this for a few moments, the state and defense have reached a resolution. So I'm just going to complete the plea form, review it with him, and then I'll ask the court to recall
Okay, well,
it.
let me let court security know not to bring him out, and I will make a note to recall the case.
Thank you, Your Honor.
Sure, I'll recall it in a few minutes. Or you just let me know when you're ready.
Yes, sir.
Okay. All right, Mr. Little, which case are you here on?
I'm here covering for Ms. Herndon on Brian Howard, Judge.
Oh, that's going to be a little bit later in the docket. We've passed Mr. Milano for a few minutes. Okay, thank you. All right. Which other attorneys do I have present? Because everybody on the list is not ready. I've got Ms. Merrifield, Mr. Cotton, Mr. Lupella, and Mr. Cruz. All right. Mr. Medina?
Yes, Judge, I could do probably a couple of out of custody. I've got roughly 10 people or more on the docket this morning, so I apologize.
Go right ahead.
And spread kind of thin. May I call Caleb Bowman? Who's
Yes.
out of custody?
Caleb Bowman, 25 CF 2197. And he is present.
Right now, yes. Do you have any out of custody to call, Travis?
I already did.
Okay. Your Honor, Steve Medina with Caleb W. Bowman, 25 CF 2197. We're here for basically twofold purposes. This is serving as his pretrial conference. The court, as an accommodation to him, has allowed him to appear today, and I would appreciate as much as possible continuing that mode, at least until he gets restored. The second thing is it's basically the status on the conditional release plan. My understanding is he's cooperating with the officer of the court who's been appointed to manage the conditional release, and I did not have a chance to reach out to her. I think the 30 days are still running for her, the entry of her report pursuant to the order that the court entered. I haven't seen that report. I apologize if I missed it. I meant to go check this morning, and I did not check again this morning.
I checked recently, and I'm looking at the file now. There was a conditional release plan that was filed on April 10th. It wasn't signed. I don't know if the court needs to approve it, or maybe a signed copy just hadn't made it to the court file yet.
I'm sorry, Judge, I did not have that in my file.
I have it, if you would like.
Well, may I just...
Sure.
Is that based, so that's satisfying that 30-day requirement then? I think that's the intent.
Let me take a look at that.
Basically supposed to be on an initial report regarding his progress in treatment, but that's just kind of getting going. And then there's supposed to be a subsequent report at a minimum of every 3 months.
I don't think this is an initial report because this is just the plan. I'm just looking through here.
Sorry, Judge.
Oh, no, that's okay. And this was filed about 11 days ago, so I'm just looking through. So the conditional release plan has blanks for several signatures, so perhaps there is a signed copy, but the one that's in the court file is unsigned, but Ms. Basso may wish to be heard.
Yes, ma'am. It does appear that this was provided by Ms. Varela from the conditional release individual's forensic mental health to Mr. Medina right on the 8th of April, I believe, given the fact that we have not seen it to sign it. I believe what would be appropriate would be for Mr. Medina and perhaps Ms. Varela, Mr. Bowman to meet, go over it, get it signed. We would then sign off on it, and then it would be given to Madam, Your Honor, to sign that as well. And then it would go into effect, but I don't believe that initial coordination, Mr. Medina, has been done yet, so however y'all office wants to handle that, I've reviewed it, don't have any objection to it.
Your Honor, I frankly am not sure what, that was the week before last when I had 3 days of family medical
Yes.
leave out of state. I don't know what role, if any, is appropriate for me to play in the drafting of that report.
Just needs to be reviewed and signed, sir. I think
I can
if-
give you my copy.
Right, but
There you go.
I'm not sure that I have a role in that.
It just wants signatures from Mr. Bowman and both
Right.
attorneys
So
and
once-
the.
Yeah, once he meets with Ms. Varela, Mr. Bowman does, Mr. Medina, if then you accept that as his attorney, you can send it over to us, we'll sign it, and then we'll give it to the judge.
I'm sorry, Judge, I just didn't see it. Is this an extra copy that I can?
Yes, you can have that. I printed it from the court file. It was just filed.
If I didn't have 10 other people this morning, then I would go over it with them now.
No problem.
This may have been something that I saw very briefly right before I flew out of town, but when we were in court almost all last week and yesterday, so can we,
Let's pass the case or reset the case for, how about May 19th? That would be our next miscellaneous day, or do you want a different day?
that's fine, Judge, and I'm also working with him on something else that's confidential that I don't have yet, so if we can set a new status for May 19th, would it be at 9 a.m., Your Honor?
Yes, May 19th, 9 o'clock, and that would be status of the conditional release plan and progress.
And Judge, I will, as soon as possible, speak with Mr. Bowman, and if we could just have him leave today and come back on May 21st, May 19th, I'll write it down for him.
May 19th at 9, and then in the meantime, y'all can review that plan. And,
Yes, Judge.
a signed copy would need to make its way to the court file, once everybody approves it.
Mr. Medina?
I don't think it'll be a problem. I apologize for not having been on top of that, Judge.
No problem, no problem. I'm just thrilled that there's a very detailed plan that has been created. That's wonderful.
When we change address, this is a form you'll have to fill out. Okay. My assistant, address here for pretrial services, and you have to fill this out, send it to the clerk, and you come to court next time. Your Honor, he's just anticipating, I think he lives with his mother, and they may be moving.
Okay.
So I've indicated to him he will need to fill out the form for the clerk. He will also need to discuss that with mental health pretrial services. He will also need to discuss that with my assistant, my legal assistant, who he knows, so that we can all be on with where he's living.
And the bondsman probably needs to know
Bondsman.
that as well. So, all right, so sir, please keep everybody updated on your address if that changes. Please let everyone know as soon as possible.
Yes, Your
And
Honor.
Thank you.
Thank you,
And
Judge.
Sure, thank you. We'll see you on May 19th. All right, Ms. Merrifield?
I'm ready, Judge, thank you.
All right.
I have John Haynes.
Okay.
Frank Merrifield on behalf of John Haynes, 24 CF 1864. We're also going to be resolving 26 MM 9190.
Okay, let me just take a look.
Did you capture that, Madam Clerk? Thank you. And the misdemeanor case, Judge, is a petty theft. And we do have an agreement from the Division ASA.
Okay.
And Judge, I just need a brief moment for a signature. We have reviewed the agreement. An opportunity to
Okay.
review it. Wonderful.
Thank you. This is case number 2024 CF 1864. Mr. John Haynes II. He's
May I
present.
approach, Your Honor?
Yes. Thank you very much.
And Mr. Haynes is withdrawing his previously entered denial. He will be entering an admission to the VOP and then a no contest to that 26 MM 9190 petty theft. Stand up here close to the microphone. And Judge, in the 24 CF 1864, the violation of probation, he'll be reinstated. We're going to modify and add substance abuse evaluation within 30 days. He'll complete any recommended treatment to start that within 60 days. There's an added cost of transportation, $1,297.35. That'll be payable through probation, the standard VOP fee and cost. And then all of the other terms previously entered will remain in effect, and his termination date will not be impacted. As to the 26 MM 9190, it's $270 in court cost, credit for time served. That'll be from March 31st, 2026. He will maintain the withhold on the felony VOP as well as the misdemeanor.
Oh, yes, it's 26 MM 919.
Thank you, Judge.
Sure. Thank you.
The site threw a few zeros on there, wasn't quite certain.
No. All right, Mr. Haynes, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you. You can put your hand down if you'll just tell me your name, please.
John Haynes?
All right. John Thomas Haynes II?
Yes, ma'am.
All right. In 24 CF 1864, it's alleged that you violated your probation. I'm looking at the amended affidavit that was filed on April 9th, 2026. It contains 4 allegations. Would you like me to read out those allegations?
It's the ones we would have in jail.
No, ma'am, that's fine.
Okay. Have you had a chance to talk to your lawyer about the 4 allegations that you violated your probation?
Yes, ma'am.
All right. And it looks like in 26 MM 919, you are charged with 1 count of petty theft, which is a second-degree misdemeanor with a maximum penalty of 60 days in jail. Have you had a chance to talk to your lawyer about that charge?
Yes, ma'am.
All right. Have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign it?
Yes, ma'am.
Is that your signature on the second page?
Yes, it is.
Do you understand the rights that you give up when you admit to violating your probation and also when you enter a plea on a new charge?
Yes, I do.
Do you understand you're giving up your right to have a contested hearing and make the state prove that you violated your probation?
Yes, I do.
Do you understand you're giving up your right to go to trial in your misdemeanor petty theft case?
Yes, ma'am.
All right. Are you entering the plea and the admission freely and voluntarily?
Yes, I am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
I have a score sheet that shows 17.8 total, I'm sorry, that's not right, it's 23.8 total sentence points. Any objections?
No objections to the score sheet was reviewed with Mr. Haynes.
All right. Is there any exculpatory DNA in the misdemeanor case?
Not to the state's knowledge, Your Honor.
None known by the defense.
I do find a sufficient factual basis based on my review of the arrest report. Sir, if you're not a U.S. citizen, do you understand you could be deported as a result of this plea?
Yes, I do.
All right. Are you admitting all 4 of the allegations in the affidavit that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made. And how do you plead to 1 count of petty theft in 26 MM 919?
No contest.
I accept your plea. I find it was freely and voluntarily entered in accordance with your agreement. On 24 CF 1864, your probation will be reinstated and modified to add a substance abuse evaluation. You must have this done within 30 days, and then you must successfully complete any treatment recommended. You need to start that treatment within 60 days. Standard VOP fees and costs will be imposed, which are a $100 VOP cost of prosecution fee and $1,000, well, this isn't a standard cost, but it's a cost that the court is imposing, cost of transportation to the Okaloosa County Sheriff's Office in the amount of $1,297.35. I believe they had to go to Illinois and transport you back. So you'll have to pay that as a condition of your probation. All other terms and conditions of your probation remain in effect. You'll still have to complete all your original requirements, and your previously ordered termination date is not changed. Now, we are, according to your agreement with yourself and your attorney and the state, you're maintaining your withhold of adjudication. I'm not inclined to do that again. If you have another violation, you're going to be a convicted felon. Do you understand that?
Yes, ma'am.
Okay. In 26 MM 919, in accordance with your agreement, there's an adjudication of, is there an adjudication of guilt on that charge, Ms. Merrifield? It's hard to tell.
It's supposed to be adjudication withheld as to both judges.
Oh, withheld, all right.
Ms. Merrifield?
Is it? One moment, Judge.
Sure.
Judge, if I could have a brief moment.
Sure.
Slight modification, Judge. On 26 MM 919, that would be an adjudication because it is a credit for time served, and that is something that was previously anticipated.
Okay.
And according to my conversation with Mr. Haynes, that doesn't change his desire to enter into and accept the plea.
All right, I'm writing that on here.
Yeah, it's okay. Okay, thank you.
So in 26 MM 919, there will be an adjudication of guilt on the charge of petty theft, and you are sentenced to time served. The court is imposing $270 in court. All right, $270 in court costs. How long to pay those costs before they go to collections?
Judge, we'd ask for 6 months to pay that before they entered into collections.
All right, 6 months to pay the court cost in 26 MM 919 before they go to collections. If those costs go to collections, that might suspend your driver's license, so. And I'm just making some notes. Sir, you have 30 days to appeal the orders of the court. If you cannot afford a lawyer, I'll appoint one for you. You'll need to see, is that Officer Keene? Yes, ma'am. All right, Officer Keene, see her before you leave this courtroom, and then does he need to check in here when he gets out? Yes. Before he goes back to? Yes. Okay, yes. So you need to be, I don't know what time you're going to get out today. If you get out before, say, 2 or 3 o'clock in the afternoon, you need to go straight to probation today. If it's after that, you're not going to make it in time, so be there before 9 o'clock in the morning.
Okay.
You have to go check in here before you can go back to Illinois. All right?
Thank you, Judge.
Thank you, ma'am.
Thank you. Good luck
That's
to you,
all I
sir.
have this morning.
Thank you. Mr. Cotton? Oh, Mr. Cruz.
Yes,
So
Judge.
sorry.
Good morning.
Good
May I
morning.
recall 18 CF 0078, State of Florida versus William Milano?
All right. William Milano, 2018 CF 78, and he'll be out momentarily. I have Mr. Cruz present on behalf of the defendant. I have Ms. Basso present on behalf of the state. And here is the defendant, Mr. Milano. Okay?
Yes, Your Honor. So for the purposes of today, Your Honor, the state and defenses have reached a resolution which calls for a reinstatement of probation with all original terms and conditions, plus 50 hours community service and $100 for the cost of prosecution.
That is the state's agreement, ma'am.
All right, so, could I see the attorneys at the bench?
Yes, Judge.
Oh, thank you. All right, so this will be a reinstate and modify to add 50 hours of community service and all original terms and conditions.
Yes, Judge.
Okay, and any other modifications?
No, Judge.
All right, and Officer King?
Yes, ma'am. Does he is still on GPS?
Yes,
So
ma'am.
they'll need to be hooked, they'll hook him up at the jail? And I also need to find out, are you still at 860 Graves Road, number B? Yes, ma'am. We need to make sure that that's okay for you to live, do what you're on for. Okay.
Mr. Cruz, you're going to prepare the written order, but let me ask Officer Keene. Officer Keene, does probation have any safety concerns if he were to be restored?
As long as, the only concerns we would have would be as long as the address, being that he is on sex offender probation, as long as the address is still a good address and there's nothing that prevents him from living at that address, and I think we should be okay.
All right, and before you bring the agreement up, I see that the Sheriff's Office is requesting reimbursement for transportation in the amount of $106.31, so the court would impose that as well.
I'll add it to the plea, Your Honor.
106.31, because I believe they had to transport Mr. Milano from Walton.
Steve tried to do that yesterday.
I've added that, Your Honor.
Thank you. Thank you so much. Very much. Thank you. That's fine. Just send it to Ms. Bozzo first. Thank you. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you. You can put your hand down if you'll just tell me your name.
William Milano?
All right. In case 18 CF 78, it's alleged that you violated your probation, and I'm looking at the violation report that was filed on October 9th, 2025, and it contains one allegation. Have you had a chance to talk to your lawyer about that allegation and any possible defenses?
Yes, ma'am.
Have you discussed this agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
I haven't signed it yet, but I have read it.
Okay, he needs to sign it. Thank you. Thank you. No problem. Thank you so much. All right, Mr. Milano, is that your signature on the back?
Yes, ma'am.
All right. Do you understand the rights that you give up when you admit to violating your probation?
Yes, ma'am.
Do you understand that you're giving up your right to have an evidentiary hearing and make the state prove the allegation?
Yes, ma'am.
In fact, that's what we were scheduled for today. Do you understand that hearing's not going to happen?
Yes, ma'am.
Is anyone forcing you or threatening you to make you admit the violation?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
Do you understand that if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
Are you admitting the allegation that you violated your probation that's in the violation report filed on October 9th, 2025?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made. The court does find that you're guilty of violating your probation in accordance with your agreement. The court is reinstating probation with all original terms and conditions and modifying to add 50 hours of community service. The following additional court costs will be imposed: $100 cost of prosecution, and also $106.81 cost of transportation to be paid to Okaloosa County Sheriff's Office. You will have to have that GPS hooked up prior to your release from jail. The court, based on the information provided by the state, the defense, and probation, Officer Keene, will make the finding that it is not a danger to the community to restore you to the probation under this agreement, and Mr. Cruz is going to send me a written order on that. That's in accordance with 948.068E. The court did consider the factors listed in that statute in making that finding. Did I cover everything, Mr. Cruz?
Yes, Your Honor.
All right. So, Mr. Milano, you will have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck, sir. See Officer Keene before you leave, and then once you get released, which is going to be probably tomorrow, I'm not sure, might be later today, you need to check in with probation. Does he come to the office in Fort Walton?
Yes, ma'am, and then we'll transfer him to Pittsburgh.
Okay, so as soon as you get out, you need to go to the probation office. If you get out later today, be there before 9 in the morning.
Thank you, Your Honor. That's all I have. May I be
Thank you.
excused?
Yes, thank you. All right. Mr. Cotton? Or Mr. Lupella? Are you ready, Mr. Lupella? All right, Mr. Lupella, we're here in 26 CF 286. Mr. Joshua Garner, who is present.
We're here on the state's motion, Your Honor.
Yes.
They filed a motion to set status conference. There's some information in that motion, which I'm sure the court's reviewed. I can update the court a little bit on what's been going on.
All right, and Mr. Ferris had requested the status conference, and Mr. Ferris, you probably need to get near a microphone so our court reporter can hear you. So let me pull up the case. All right.
Your Honor, the state requested the status conference. As you'll recall, the defendant was arrested on February 6th and charged with aggravated assault with a deadly weapon. State later added an additional misdemeanor charge for a concealed weapon in a prohibited place. On March 19th, an order revoking bond and commanding defendant's arrest was signed by this court. That order was entered based on an affidavit from pretrial services establishing probable cause that defendant was in violation of at least one of the conditions of his pretrial release, and that was specifically he was continuing to carry firearms despite Your Honor's very clear admonitions that he not do so, whether that's in Florida or whether that's in Arkansas or anywhere else. On March 24th, defendant was arrested in Lenoke County, Arkansas, on that order. He was, as I understood it, was originally refusing extradition to Arkansas. In addition, pretrial services indicated that it's their policy to not get involved with extradition matters. For that reason, we set a motion for a status conference to see whether or not setting that status conference might get Mr. Garner here so that we could progress the case. Now that Mr. Garner is here, we would ask that he be placed into custody.
How is Mr. Garner not in custody?
He was released from Arkansas, Your Honor.
Okay.
They released him from their hold.
My understanding is that he was, and
Yeah.
I don't know for sure. My understanding was that they were only going to hold him so long pending extradition, and upon essentially being notified that at this point pretrial services wasn't going to get involved, and therefore we weren't in a position to get the governor involved to get extradition, that they released him because they simply couldn't hold him. They felt they couldn't hold him any longer.
All right.
And if I may, Your Honor, to
Go ahead.
respond. Basically, just to kind of go back in time a little bit here, we had an ex parte motion and order, well, I guess it was a good cause order to revoke his bond based on weapons issue. And what the court doesn't know or didn't know from Mr. Lorenzo's affidavit was that there was a plea agreement that my client had signed off on when he was represented by a previous attorney that would have disposed of his case. He signed off on it, submitted it to his attorney, and then it had not been submitted to the state or approved by the court or hadn't finalized. So he was under the impression that he was going to be able to possess firearms because the case was concluded. So he was under that, I guess you could say it was a misapprehension, Your Honor, but it wasn't in it wasn't in a willful sense. He thought he could have weapons again. So that was the basis of that issue. I know that we could provide the court with proof that that was in fact the trajectory of the case at the time. But of course, for whatever reason, the case was, the plea agreement was not ratified by the state or the court. And so therefore, Mr. Garner was technically in violation of his pretrial release, even though I would argue that it wasn't willful. He was arrested. He was held in Arkansas. He, as far as the extradition issues and how that would worked out, all I can say is that he was released after spending about 20 days in jail. And when I told him he has a court date here today, he immediately came down here from Arkansas, traveled down here, and is present before the court when coming from Arkansas, which I think would go against the issue that he was trying to fight, answering for these charges. That being said, Your Honor, we understand that there is an order revoking this bond that the court has signed off on. We have not had a hearing on whether or not this bond should be revoked. It's just that it was done ex parte. I would ask the court to consider having a hearing on the bond revocation, to consider the totality of circumstances and whether or not it's appropriate. If the court is not inclined to do that, I would ask that the court consider allowing my client to enter into the 12 Oaks program, which he's been accepted to according to him, and allow him to do that as a condition of his pretrial release. While I work out some of the issues which I think are resolvable in this case between the military, his psychologist, and the state in being able to fashion a resolution to this case without him just languishing in jail, when he definitely, all appearances are he does have some dual diagnosis issues that we need to address. And I think that's not necessarily, I don't know if it's, well, it's being recommended through the military. He's still an active duty member. So I've presented the state with contact information for psychologists. I've asked my client to release any of that information to the state as far as his psychological issues or anything like that. And so that the state can talk to those folks and be able to feel good about a disposition in this case that we're trying to reach. One of the options that the state has looked at and presented me with is the possibility of him doing Veterans Court in Arkansas. I've never been able to figure out if there's a way to do that from state to state, especially as a diversion. It would be unprecedented from my standpoint, and I've never heard of it being done. But I would seriously consider trying to do something like that for Mr. Garner, especially if he's not in custody. I think then we could look down those options. That being said, I defer to the court as far as how the court wants to go forward in this situation.
Your Honor, if I might, with respect to the vet court issue, that was not necessarily a formal offer. It was more of a note that, like, if Mr. Garner was a resident here, this case seems like it would scream vet court. And so and I'm aware that there is something equivalent to a vet court in Arkansas, and so I suggested to Mr. LaPella, if there is some sort of way that you can sort of figure out how that might work, the state might be amenable to that. The state is very willing to be creative with respect to what a resolution might look like. The issue with 12 Oaks, as I understand it, that's a 28 or 30-day program or something along those lines that would be inpatient. And from the state's perspective, in light of the violation of the pretrial order that Your Honor put in place, 20 or 30 days, the state does not believe adequately protects the community. So all that's to say, the state is very willing to consider all sorts of creative resolutions here. What's been proposed thus far is not quite there yet. And I don't know what that ultimate resolution might look like, but from the state's perspective, it's not a month in 12 Oaks or whatever that might be. And as for the initial offer, that offer was revoked by the state upon me getting a phone call from a police officer in Arkansas about what was going on in Arkansas, which prompted the motion for order to revoke.
So, Mr. LaPella, I haven't heard any evidence. I've heard a proffer.
Right.
What is the alleged date of that alleged agreement that was not ratified by the state or the court?
Do I know the alleged date of that?
Yeah, what was the date of that supposed agreement?
Yes, Judge, I believe it was around March 9th. I think my client signed it around March 12th. But
all right.
In the interim,
thank you.
That's when that would have, and it also would also make sense in terms of the chronology that he might have been under the impression that it was resolved, and then the intervening, that the officer from Arkansas, very zealous officer, was very interested in Mr. Garner's dealings, was able to notify the state that he had maybe jumped the gun on having firearms, no pun intended, before it was ratified. And I think that's just the naivety of my client, thinking that it would have been as a done deal, he could have his guns back, and it wasn't a done deal because the state hadn't signed off on it, hadn't made its way through all the channels. And this is information I've gotten from my client, as well as his former attorney, Mr. Gates, and the state.
And Your Honor, if I might, if Mr. LaPella wants to set a motion with respect to bond, the state would be amenable to that. We would be calling a probation officer who, as my understanding, would be testifying to the fact that immediately upon informing Mr. Garner as to what he can and can't do, he was perhaps trying to be cute as far as like, oh, I understand I can't have firearms in Florida. Like, no, that's not it. You can't have, you very specifically stated that you cannot have firearms in Arkansas, knowing that he was resident in Arkansas, absent some sort of, an officer that required that he have a firearm for purposes of his Air Force service. So all that's to say, if we need to have a motion hearing, there will be evidence that the state will provide with respect to what. the sufficiency of his compliance with Your Honor's order.
Mr. Garner's going to be taken into custody right now on the warrant. So, Mr. Lupella, if you would like to file a motion, of course, I'll set it for a hearing, but the underlying charge here is serious, and the allegations in a sworn affidavit are very concerning. So he is going to be taken into custody right now. So,
And Your Honor, I would request that the court set today a hearing date, as the state was afforded a special hearing that I stipulated to for the 21st. I was contacted by the state. I agreed to that court date for the 21st on a special date and did not object. I'd ask the court to set it today if possible.
what do you mean set it?
Set another, if I can have a hearing on his bond and status, I would ask the court to afford me the same ability to do that.
Right, the status conference today was because it was communicated that he was, well, that's what it says in the motion, that he was fighting extradition. So that's why the state requested a status.
Actually, Your Honor, I was contacted by Ms. Maltese from the state's office asking me to agree, if I would agree to a hearing date for this and if I was available to be present. And I said I agreed, and I stipulated to the hearing. If the state, I would ask the court to allow me to have this set for a bond revocation hearing in light of the fact that I agreed to stipulate to this date today.
The state certainly doesn't have any objection to Your Honor setting a hearing. We just ask that we have a sufficient time for.
I would just ask the court what's the next available date, because I'm afraid of him languishing in jail, considering I've already waived from the last court date. I would have set it for trial if I knew he was local and he was in jail. So.
Well,
we only
like I said, the underlying charge here is very serious, involves a firearm, and the allegations upon which the court revoked the bond are in a sworn affidavit regarding firearms. So it's concerning, it's very concerning.
Of course it's concerning, Your Honor. We're not disputing that it's concerning. We just asked the court for due process in terms of that. I don't know if the court would afford us due process or afford us the ability to argue that he's entitled to a bond considering the totality of circumstance, or argue those facts that led up to those just sworn affidavits with no evidence. That's just a sworn statement. But I'd ask the court to allow me to set it. I would just ask what the next court date is that I could have.
Of course, I'm trying to give you that, and of
Okay.
course, the court will provide your client with due process.
Well,
And the court
it's
is permitted
difficult.
to revoke his bond based
I
on a
understand.
sworn affidavit, especially one as concerning as this one, that, I'm looking at the affidavit, and it says that the officer in Arkansas retrieved over 50 firearms from your client's residence within a very short period of time after he was released on bond in order to surrender said firearms. So the court is concerned, and that is why bond is revoked based on this sworn affidavit. Of course, you can have a hearing. Here are your dates available. We have May 19th. We have possibly May 14th. Let me take a look at it. And we have May 21st. So
What was the first one, Your Honor?
May 14th.
May 14th, 19th, and 21st, but I need to look at the 14th. That might be full. Because if we're going to have an evidentiary hearing, we're going to need sufficient time, and I've got several things.
I would ask the court, that's at least 3 weeks away. I would ask the court to set it as soon as possible. So the 14th, if that's the best I can do, that's the best we can do.
I'm looking because that might be full. I know I've set several things on the 14th already that are evidentiary hearings. We have a giant afternoon docket on the 14th of May. It's looking like we're going to need to do that on May 19th. I just don't see time. on the 14th. Now, what we can do is take a look at that date as it gets a little closer, and if the morning docket on the 14th is not as crowded as I think it is right now, and if it looks like there's time, then we could do it on the 14th, but I'm hesitant to do that right now. It looks like it's completely full. So, May 19th at 9 o'clock, but you need to file a motion. And we also need to set pretrial, which would be, right now I'll set it for June 8th at 9 o'clock. Might already be set for that date, I'm not sure. But, oh, I think it's set for June 10th already. So what I'll do is put it on the 8th for pretrial conference, June 8th at 9. But you do need to file a motion for the May 19th date and a notice of hearing. And please file it within the next, well, when can you file it so that the state has time to review it in sufficient time prior to the hearing?
I'll file it as soon as possible.
Okay, what is that? Is that like within a week?
Sure.
2 weeks?
Sure.
I just don't want it to be filed like the day before.
I understand. Well, first of all, part of the issue, Judge, is the court signed a bond revocation on hearsay of a pretrial release officer, not on, it can be a sworn affidavit, but it's based on the statements of another person.
Okay.
The court did not have the affidavit from the officer from Arkansas that it
Okay.
would have needed in order for that to be legitimized as good cause. So
I understand what
that's
you're
one
saying.
issue.
I don't mean to cut you off. I do have a large docket today. I've given you a court date. When can you file your motion? Within 2 weeks, do you think that would be legitimate as far as time frame?
I can file it this week, Your Honor.
Okay, how about within a week so that the state has time to review it? If we can get you in sooner, we will. If you'd like to check with Amanda, not today because I don't know, I'm going to be in court all day. I don't have time to get with her, and I set some things on the 14th just recently. If we can get you in on that May 14th date, if there's time available, we will. I'm setting it on the 19th right now because I know there's time available on that day. But if I can move it up, I will do so. Reach out to Amanda on a day other than today so that I can make sure she has the most recent updated information on the date.
Okay.
And please file a notice of hearing.
Of course, Your Honor.
All right.
Thank you.
Thank you, Mr. Lupella. Mr. Cotton, are you ready?
I am, Your Honor.
All right.
Your Honor, you called me a couple of times. I apologize. I had to do Zoom first appearance this morning, so I was unable to jump in. I had to do it in a side room.
Okay, this is Ms. Felicia Wharf.
It is, Your Honor. We have a signed plea agreement, if I may approach.
Okay, this is 2019 CF 1323. Thank
Yes,
you
ma'am.
very much.
Had to do this.
Okay. Thank you.
Your Honor, for the record, Byron Cotton, present with Ms. Wharf, case number 29 CF 1323. We're before the court. We've reached an agreement with the state, and I've put that on the court's VOP plea agreement for your review. As you can see, Judge, there's been some manual annotation changes after discussions with the state this morning. My client has agreed to those, and they have been initialed.
Okay, just one second. Could you come here for just a second? Thank you. All right, ma'am, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you. You can put your hand down. If you'll just state your name for me, please.
Felicia Nicole Ward.
All right. And you are here on allegations, or one allegation that you violated your probation in case 2019 CF 1323. I'm looking at the amended affidavit that was filed on December 5th, 2025. And let me make sure I have the most recent one. I do. It has one allegation. Have you had a chance to talk to your lawyer about that allegation? You violated your probation and any possible defenses?
Yes, ma'am.
All right. Have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature at the bottom of the second page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Or I should say, the rights you give up when you enter an admission to a violation?
Yes, ma'am.
Do you understand you have the right to have an evidentiary hearing and make the state prove the allegation?
Yes, ma'am.
And do you understand you're giving up that right?
Yes, ma'am.
Is anyone forcing you or threatening you to admit the violation?
No, ma'am.
Has anybody promised you anything to make you admit the violation?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
Do you understand that if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
Are you admitting the allegation that's alleged in the amended affidavit that was filed on December 5th, 2025?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. In accordance with the agreement, the court does find that you're guilty of violating your probation based on your admission. I believe there's already been an adjudication of guilt on the underlying charge.
Yes, ma'am, there has.
Thank you. Your supervision is reinstated and modified as follows. You will spend the next year on community control. And there are some special terms and conditions that will apply to that. You may have contact with your grandchild in accordance with Florida Statute 948.30, subparagraph 1E. Internet access may be allowed upon completion of a risk assessment and implementation of a safety plan.
And there's a $100 VOP fee, Judge.
$100 VOP fee. Just checking, I don't think there are any other costs or anything that are imposed. Did I cover everything?
Yes, ma'am.
Yes, ma'am.
All right. So, ma'am, you'll have 30 days to appeal the order of the court. And if you cannot afford a lawyer, I'll appoint one for you. And you'll need to see Officer Keene before you leave the courtroom, but there's also a warrant for a
There's a
new...
warrant?
There's
For
a
what?
warrant for a new violation, a new charge. A brand new charge, not a VOP.
What is the new
Oops,
charge?
There's a warrant.
Okay.
I did not sign the warrant. Another judge
understand.
signed the warrant, and it's
I'll-
a different date than we're dealing with today.
What was it?
That's good. Good.
So-
Thank you, Judge.
Thank you, Mr. Cotton. All right, Mr. Patel, are you next?
Thank you, Judge.
Thank you.
I have Brian Klein.
All right.
He's an inmate. Judge, I've been notified that Mr. Klein has a family law hearing this afternoon, and my assistant asked me to remind the court that he not be transported back so he could be at that hearing with Judge Brown at 2 p.m.
Okay, has that arrangement been made for that to happen?
I don't know.
I don't know either. I mean, yeah, that might be something you'll have to
That's
talk
just what I
to.
was told to tell
You
you.
might have to talk to booking about that, or
Okay.
court security. I'm not, I don't know what the transportation schedule is or anything about that.
Does he have to, I'm curious, because I don't know the answer to this. Does somebody in jail that has to be a party to the case, do they have to file their own motion in order to appear from the jail live? Or should the other party do that?
Usually the person incarcerated has to request it. I don't know if he's represented in that family law
He's
case or
not.
not. Oh, okay.
Makes it more challenging.
Yes. All right, so
Okay.
Mr. Klein is present and the...
He's before the court,
Mm-hmm.
25 CF 1760, 26 CF 45. These are both VOPs, they're misdemeanors.
Wait, just one second. Give me that 25 case number again.
1760,
2025 CF 1760, and then 26 CF 45.
that's correct.
Okay.
Judge, at this time, Mr. Klein would be withdrawing his previous denial and entering into an admission. The understanding is that they would reinstate probation with Judicial Correction Services County Court probation with all original terms and conditions, $100 VOP fee for each case. The defendant shall not own, possess, purchase, or attempt to purchase any firearms or ammunition during the duration of probation. The defendant will check into probation immediately upon his release from incarceration. Just so the court's aware, he has a Walton County case, which there is a hold, or there will be a hold, and there's apparently a federal indictment, so there's just some things that are going to be happening before he's eligible for release. And that he will, if he's released before 5 p.m., he'll check in that day. If he's released after 5 p.m., then he'll check in the following day. He will be adjudicated guilty on both. May I approach?
Yes. Thank you very much. Thank you. Let me look up that other case because I only have one popping up. All right, Mr. Klein, if you'll please raise your right hand. Other hand.
I'm sorry,
There you go.
ma'am.
That's okay. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Brian Klein.
Thank you. In 25 CF 1760, it's alleged you violated your probation. There are, let me count.
It's the first violation, Judge.
Yeah, there are 5 allegations in the affidavit in that case. And then, let me look at 26 CF 45. It's also alleged you violated your probation in that case. There are only 2 allegations in that case. Have you had a chance to talk to your lawyer about the allegations that you violated your probation in both cases?
Yes, ma'am.
All right, have you discussed this agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the second page?
Yes, ma'am.
Do you understand the rights that you give up when you admit to violating your probation?
Yes, ma'am.
Do you understand you're giving up your right to have an evidentiary hearing in both cases and make the state prove that you're guilty of violating your probation?
Yes, ma'am.
Do you understand that we were scheduled for that today, and in light of your plea, that we will not be having those evidentiary hearings on those cases?
Yes, ma'am.
All right. Is anybody forcing you or threatening you to admit the violations?
No, ma'am.
Has anybody promised you anything to make you admit the violations?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
Oh, Janet took my medicine this morning.
Just tell them.
I took my mood stabilizer. Well, no, actually, this morning I did not. I took my heart medication.
Okay, let me ask, is there any medication
For high
that you
blood
took
pressure.
that would affect your ability to understand what you're doing right
No,
now?
ma'am.
Okay. Are you suffering from any mental health condition that affects your ability to understand what's happening right now?
No, ma'am.
Okay. Are you admitting all of the allegations in both cases that you violated your probation?
Yes, ma'am.
I accept your admission in both cases. I find it was freely and voluntarily given. And it looks like there's already an adjudication of guilt on the underlying offenses in both cases. The court does find that you're guilty of violating your probation. In accordance with your agreement, your probation is being reinstated with the original terms and conditions. I believe this is already a term of your probation.
It's a natural term of all probations, but the state
We're going to
is-
emphasize it.
That's right.
Okay. So, sir, let me emphasize this specifically. You shall not own, possess, purchase, or attempt to purchase
That was a
any
big mistake.
firearms or ammunition while you're on probation. Do you understand?
Yes, ma'am.
And you will check in with probation Well, let me swear you in, and we will go through the Ferretta inquiry, okay?
Yes, ma'am.
Just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you. You can put your hand down. If you'll state your name for me.
Brian Howard.
Thank you. Sir, do you understand that you have the right to have a lawyer?
Yes, ma'am.
Do you understand that if you cannot afford to hire your own lawyer, one will be appointed for you?
Yes, ma'am.
Do you understand that the state of Florida will pay for a lawyer to represent you if you cannot afford one?
Yes, ma'am.
Do you want me to appoint a lawyer to represent you?
No, ma'am.
Let me tell you some of the ways a lawyer can help you prior to trial. A lawyer's legal knowledge and experience may assist you in attempting to set bond, reduce bond, or obtain pretrial release. I do see that you're out of custody, so the part about bond doesn't really apply at the moment. A lawyer may obtain information about the case through skillful use of discovery devices. A lawyer may discover possible violations of constitutional rights and take the proper steps to address them. A lawyer may make sure the speedy trial rule and statute of limitations are enforced. A lawyer may identify and obtain favorable evidence to introduce at trial on your behalf. A lawyer can, if appropriate, file motions to exclude evidence, to suppress evidence, and to dismiss or reduce charges against you. Let me tell you some of the ways a lawyer can help you in deciding whether to enter a no-contest plea. A lawyer can advise you as to whether entering a plea is in your best interest. A lawyer has the experience to help you work with the state and even bargain for different terms. A lawyer can tell you the advantages and disadvantages of what you might say to the court during your plea hearing and the sentencing hearing that will follow. Do you understand that you will not get any special consideration from the court just because you're representing yourself?
Yes, ma'am.
Okay. Do you understand how necessary a lawyer is and how he or she could help you?
In a normal case, I do, yes.
Okay. You are currently charged with, let me bring up the information so that I can read off that. And Mr. Little, I may need the state to direct me as to the most current information. I do see an amended one was filed on January 16th, 2026. Is that the most current?
I believe so, Judge.
Okay. So, Mr. Howard, have you seen the amended information that was filed on January 16th, 2026?
I'm not sure what you're talking about.
Okay. The state filed an amended charging document called an information, and it has 3 charges. I'm going to read them to you because this is what you're currently charged with.
Okay.
Count 1 is aggravated stalking by violating injunction or court order, and it is alleged that on or about or between August 13th, 2022 and August 19th, 2022 in Okaloosa County, Florida, after an injunction for protection against repeat violence, sexual violence, or dating violence, or an injunction against domestic violence was entered, or after any other court-imposed prohibition of conduct towards Elisa Marie Reed or her property that you did unlawfully, knowingly, willfully, maliciously, and repeatedly follow, harass, or cyberstalk that person in violation of, and it cites the statute. That's a 3rd-degree felony with a maximum penalty of 5 years in prison. That's count 1. Count 2 is accessing a computer system without authorization. I'm going to read that one to you as well, okay? It's alleged that on or about or between August 13th, 2022 and August 19th, 2022 in Okaloosa County that you did unlawfully, willfully, knowingly, and without authorization access or cause to be accessed any computer system, or computer network, Facebook application via cellular phone, the property of Elisa Reed in violation of, and it gives the statute numbers. That is also a 3rd-degree felony with a maximum penalty of up to 5 years in prison. Then count 3 is unlawful use of a 2-way communication device to facilitate the commission of a felony And this is what the allegation is. It alleges that you, on or about or between August 13th, 2022 and August 19th, 2022 in Okaloosa County, Florida, did unlawfully and knowingly use a two-way communication device, specifically a cell phone and/or computer, to facilitate or further the commission of a felony, the felony being aggravated stalking in violation of, it gives the statute number. That's also a third-degree felony with a maximum penalty of up to 5 years in prison. So those are the current charges based on the amended information that was filed on January 16th, 2026. It's in the court file, so you can
Well,
look at it
those
there.
are the original charges.
I'm not aware what was amended without going through and
Right.
trying to piece it together, but that's the most current information in the court file.
Yes, ma'am.
With the charges. So, the next question is, have you received a copy of these charges and had a chance to review them?
Yes, ma'am.
Okay. Do you understand the serious nature of the charges against you?
Yes, ma'am.
The maximum sentence that can be imposed against you is, it's a total of 15 years. That's if you were found guilty on all 3 counts and if the sentence was run consecutive. That's
Yes,
your
ma'am.
maximum exposure. Do you understand?
Yes, ma'am.
Is the state seeking any type of enhanced penalty?
Not that I'm aware of, Judge.
Okay. Sir, you may be required to report to a probation or community control officer if you were either to enter a plea or if you were found guilty. You may be required to pay a fine or restitution. You may have a permanent criminal record. If you're not a citizen of the United States, you could be deported from the country or excluded from entering the country in the future or denied the opportunity to become a naturalized citizen. Do you understand these consequences of entering a plea?
Yes, ma'am.
Do you have any questions about the consequences that I listed?
No, ma'am.
If you don't fulfill the conditions of a plea, if you were to enter one, the state could ask to revoke your probation or community control, and you could be arrested and brought back to court for a revocation hearing. Do you understand that?
Yes, ma'am.
All right. So let me tell you some of the ways a lawyer can help you at trial. A lawyer has the experience and knowledge of the entire process. Your lawyer will argue for your side during the whole trial and present the best legal argument for your defense. Since jury selection is governed by lots of legal procedures, a lawyer's knowledge and experience may give a lawyer an advantage during the selection process on your behalf. A lawyer can call witnesses for you, question witnesses against you, and present evidence on your behalf. A lawyer can advise you on whether you should testify, the consequences of that decision, and what you have a right not to say. A lawyer has studied the rules of evidence and knows what evidence can and cannot come into your trial. A lawyer can make objections during the trial to try to keep certain testimony and evidence from being introduced at trial. A lawyer may provide assistance in ensuring that the jury is given complete and accurate jury instructions by the court, may make effective closing arguments on your behalf, and may prevent improper argument by the prosecutor. A lawyer may ensure that any errors committed during the trial are properly preserved for appellate review later by a higher court. If you are convicted, a lawyer may prepare for sentencing and make sure that favorable facts are brought to the attention of the court. A lawyer may make sure that the court is aware of all legally available favorable dispositions. A lawyer can make sure a proper pre-sentence investigation report is prepared on your behalf. A lawyer may help bring witnesses to court to testify on your behalf at sentencing. A lawyer may make sure that any sentence is lawfully imposed. An attorney's legal knowledge and experience may be useful in filing an appeal and in seeking release on bail pending the appeal. These are the dangers and disadvantages to self-representation. As it is almost always unwise to represent yourself in court, Let me tell you a few of the disadvantages of representing yourself in court. Do you understand you will not get any special treatment from the court just because you're representing yourself?
Yes, ma'am.
Do you understand you will not be entitled to a continuance simply because you wish to represent yourself?
Yes, ma'am.
All right, you're not in custody. The next couple of points don't really, they don't apply to you, but if you were in custody, you'd be very limited in the legal resources available to you in the jail, and you wouldn't get any additional library privileges if you were in custody just because you're representing yourself. You're not required to possess the legal knowledge or skills of an attorney in order to represent yourself. However, you will be required to abide by the rules of criminal law and the rules of courtroom procedure, not to mention the rules of evidence as well. These laws took lawyers years to learn and abide by. If you demonstrate an unwillingness to abide by these rules, I may terminate your self-representation. Do you understand that?
Yes, ma'am.
Do you understand that if you are disruptive in the courtroom, that I can terminate your self-representation and remove you from the courtroom, in which case the trial would continue without your presence?
Yes, ma'am.
Do you understand that your access to the state attorney who is prosecuting you will be severely reduced as compared to a lawyer who can easily contact the state attorney?
Yes, ma'am.
In addition, do you understand the state will not go easier on you or give you any special treatment because you are representing yourself?
Yes, ma'am.
The state will present its case against you by an experienced lawyer.
Yes, ma'am.
If there is a stay-away order in effect against you, and I believe based on these charges there likely is,
I think that was all dropped. The restraining orders were dropped a couple of weeks ago.
okay, well, let me check the conditions of your pretrial release, because it might be, I'm suspecting it might be a condition of your release. Okay, I'm looking at an order setting bond. It was entered September 13th, 2022. I do not know if it has been modified. I'd have to go through, there are hundreds of court documents.
Yeah, it doesn't matter. I don't go around
Okay.
anybody.
So you are under, according to this order, you're under a no contact order with the following individuals: Elisa Reed or her family, and Joseph Persley. So that means you're prohibited from contacting those individuals
Yes, ma'am.
as part of your discovery
Yes,
or in anything to do with this case. But if you are represented by an attorney, your attorney is allowed to speak to these people and question them regarding their testimony.
Yes, ma'am.
If you are convicted, you cannot claim on appeal that your own lack of legal knowledge or skill constitutes a basis for a new trial. Do you understand that?
Yes, ma'am.
In other words, you cannot claim that you received ineffective assistance of counsel when you're representing yourself.
Yes, ma'am.
Do you understand all of these dangers and disadvantages of representing yourself?
Yes, ma'am.
Do you have any questions about these dangers and disadvantages?
No, ma'am.
During the time that you were represented by counsel in this case, did you discuss the case with your attorney? I do not need to know and don't want to know what you discussed. I just need to know if you had a discussion.
Yes, ma'am.
Let me advise you of some of the possible penalties if you are found guilty of all of the charges. I went over the maximum prison sentence that you would be facing if you were convicted on all of the charges already. Some other consequences would be you may be placed on probation or community control for a period of time. You may be required to pay a fine or restitution. You may have a permanent criminal record. I already went over the possible deportation if you're not a U.S. citizen. Do you have any questions about the charges or the possible consequences and penalties if you're found guilty?
No, ma'am.
Okay. Next, I need to ask you a few questions about yourself to determine if you are competent to make a knowing and intelligent waiver of counsel. How old are you, sir?
53.
Please don't be insulted by some of these questions. I am required to ask them, okay? Can you read and write?
Yes, ma'am.
Do you have any difficulty understanding English?
No.
Okay, that is evident from
Right.
conversations that we've had during the few hearings we've had together, that you do not have any difficulty understanding English, and I'm aware that you can read and write because you filed things in the court file. How many years of school have you completed?
High school.
Are you currently under the influence of any drugs, alcohol, or any type of substance?
Just gabapentin and just back medicine. I
Okay.
had back surgery 6 years ago.
Does that medicine affect your ability to
No.
understand what's going on?
No.
Does it make you groggy or unaware of what's happening?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what's going on right now?
No, ma'am.
Okay. Do you have any physical problem that would hinder your self-representation, such as hearing problems, speech impediment, poor eyesight, mobility issues?
No, ma'am.
Has anyone told you not to use a lawyer?
No, ma'am.
Has anyone threatened you not to hire a lawyer?
No, ma'am.
Have you ever represented yourself in a trial?
No, ma'am.
Do you have any questions about having a lawyer appointed to represent you in this case?
No, ma'am.
Having been advised of your right to counsel, the advantages of having counsel, the disadvantages and dangers of proceeding without counsel, the nature of the charges, and the possible consequences in the event of a conviction, are you certain that you don't want the court to appoint a lawyer for you or find a lawyer on your own?
Yes, ma'am.
All right, I'm about to finish the inquiry, but I'm so concerned. I see this frequently.
It's taken, between you and I, this has taken way too long. My son, I mean, you
I know
know
that-
what's going on in this town.
Well, I understand that there are other possible cases that may be implicated, and that, I understand that. I'm very concerned anytime I see somebody representing themselves in criminal court, because there are so many technical rules and requirements. Jury selection alone is complicated.
I'm concerned myself. It's like I said, when you and I first talked, let me put a hammer in your hand and have you build a house in front of me. It's
It'd be
impossible.
like me trying to perform surgery on myself.
Correct.
That's how I look at somebody representing themselves in court. I'm
But
very
this-
worried.
This is what Okaloosa wants. This is what Okaloosa's gonna get. And it's like I said, I'm done. 4 years, $147,000 into this stupid stuff.
Are you lumping other cases in that?
Yes, ma'am.
Okay,
The other cases that she falsified and that they were dropped.
And I'm not assigned to any
Right.
other cases. This is the only one that I'm aware of that I'm assigned to. So, I think I've appointed previously the PD as standby counsel. Mr. Gates, didn't I do that last time?
Yes, Your Honor, I think it's going to be Mr. Koch who's going to be the standby counsel in this
Okay.
case.
So I am going to continue to appoint standby counsel, although, oh, there's Mr. Koch.
Sorry,
I was looking at the wrong table. So, and I know you advised last time, or one of you did, that there's not a lot you can do.
Yes, Your Honor, but I'll be standby counsel, Your Honor.
Thank you. All right. So, Mr. Howard, do you know how to get a hold of Mr. Koch?
No, ma'am.
Okay.
Provide my card, Your Honor.
Okay. And he probably needs to know how to get a hold of you if necessary. So, sir, I do find that you're competent to waive your right to counsel. I find that your waiver of your right to counsel is knowing, intelligent, and voluntary. well, let me ask Mr. Little, is there anything you'd like the court to inquire or put on the record regarding Mr. Howard's waiver?
No, Your Honor. The inquiry was sufficient.
Okay, thank you. All right, so, Mr. Howard, at any time, if you wish to hire a lawyer, and I sincerely encourage you to continue to do so.
There's none out here. When
There's got to be. I mean, there's hundreds and hundreds of lawyers that you could.
And every one of them hear about Okaloosa County, and everybody's afraid of Okaloosa County.
Okay. Not sure exactly what that means, but I'm encouraging you to continue to look for an attorney to represent you, because I read you the Ferretta inquiry that I'm required to read you.
Yes, ma'am.
In my opinion, until you are in a trial, you cannot grasp the magnitude of the disadvantages of
Right.
representing yourself.
Right.
Especially against an experienced prosecutor. There are so many technical rules that, like I said, I look at it like if I tried to operate on myself, that would be about the equivalent.
Yeah, it's like I
So-
said, I'm just looking for a jury to say guilty or not guilty.
Okay,
Let them decide this.
all right. Let me just make a few notes.
And then we've got another court hearing coming up.
Yes. So I know that I set you'd filed some motions, and I set those for a hearing on May 14th at 9. I haven't entered the order setting the hearing yet because I wanted to get through today to make the findings of whether or not you're going to be representing yourself. Now I will enter the order setting the hearing, but now that Mr. Little is here, let me make sure that that date works with him. It's May 14th at 9 o'clock, Mr. Little. There are several motions that Mr. Howard has filed.
I believe Ms. Herman is aware of that hearing date, and I don't believe that there's a conflict.
Okay.
So I'll text her as soon as court's over, and if there's an issue, I'll make sure that she contacts the JA as soon as possible.
Okay, and will you be on the case, or will Ms. Herndon be on the case? Or do you all know?
It's Ms. Herman's case.
Oh, okay.
For today.
Oh, okay, yes. Ms. Herndon was present whenever I set that court date, so I think we, obviously, she cleared that. So, Mr. Howard, let me just double check. Looks like you're already scheduled for a pretrial conference on June 8th.
Correct.
At 9, and we've got your motion hearing set for May 14th at 9, and I'll get that order entered setting that. Now, that's on 3 different motions that you filed. I'm not aware if you've filed any others or if you're planning to.
Yeah, we're in the process of putting one final together.
Okay. You are?
Yes, ma'am.
When are you planning to file that?
Within the next day or two.
Okay, because I saw that you filed a lot of motions, like the day of our last
Yes,
hearing last week. That wouldn't be sufficient time if you filed it like the day before, the day of,
Right.
2
No,
days before.
Yeah, it should all be in by this week.
Okay. So make sure that you send a copy to the state attorney that's handling the case, Ms. Herndon, so that she has time to review it and prepare. Anything else I need to cover from either the state or Mr. Howard or Mr. Koch?
I'm good.
Your Honor, just briefly, last time, Mr. Medina kind of explained a little bit about standby, my limited role.
Yes.
Just because we're kind of in a unique situation where Mr. Howard here doesn't qualify for the public defender. So if this does go to trial, I'll be standby sitting in the front row to answer questions, but this won't be or let me phrase that, if he wants an attorney, during trial, during jury selection, our position is I can't just jump in because of that.
I
So I just want to make sure that's clear again and kind of stress what you stated earlier. I advise always someone to talk to a lawyer, see if you can get a lawyer. So I just want to state that again for the record, Judge.
Thank you, Mr. Koch. So, sir,
Yes, ma'am.
if you hire an attorney at any time,
Right.
they will come in, they will file paperwork, they will take over, you know.
They'll drag this out way too long.
Well, you know,
I'm ready. I mean, it's
the alternative is you representing yourself at trial, which is, you know.
it's either death or this continues. I mean, I'm ready. I'm done.
Okay.
It's like I said, I'm just done.
Well, so I know Ms. Herndon is not here right now, but I believe we mentioned this at the last court date. Our trial dates for the next cycle are going to be either the week of June 22nd or the week of July 6th.
Yes, ma'am.
I don't know which of those your trial will be,
But we
but
all-
so that everybody can plan ahead,
Right.
that's what we're looking at, is
Okay.
to bring the case to trial either in late June or early July.
Okay.
And again, I would encourage you to continue to look for lawyers,
Yes,
please.
ma'am.
Okay.
Thank you.
All right, thank you. All right, thank you.
That's all I have, any issues?
Yes, thank you.
Thank you, Judge.
Do I have Ms. Dawn Byers present? This is case numbers 23 CF 341 and 22 CF 1606. And Ms. Byers is present, and my paperwork shows that you don't have an attorney. I think that I was about to appoint an attorney last time, but
Yes, you allowed me to convert my community service to a buyout, but I need to request that I can be put on a payment plan, because, for all of that.
okay. So let me take a look. And let me defer to Officer Keene. I know that the allegations were cost of supervision, and drug testing fees, and let me just take a look at,
Those were waived, I thought.
okay, let me take a look. Okay, from the last court date, which was March 17th, it looks like you were permitted to buy out community service. I'm not sure about the waiver. I'm looking. Let me see what the state's position is. And first of all, would you like me to appoint a lawyer to represent you?
I don't think it's necessary. If I can get a payment plan, I can go ahead and start that today for all the costs and everything.
Okay. Let's see what the state has to say.
Your Honor, I just spoke with probation. She has a total of $4,175.60. She has not paid absolutely anything during this term of probation. Now, this is a strictly monetary type of situation. I'm willing to give her a chance to pay.
I just need a payment plan, that's it.
I think I better appoint a lawyer for
Yeah,
you if
okay.
you'd like me to.
Okay.
I'm appointing the Office of the Public Defender. And Mr. Medina, this is Dawn Byers, case numbers 22 CF 1606 and 23 CF 341.
Your Honor, I
Yes.
wasn't, thank you, Your Honor. Sorry.
Go ahead. It's a violation of probation. It looks like we were in court on March 17th, and we continued the case till today, and here we are. So,
Does the state have an offer? I apologize, I wasn't listening.
She's been given 2 withholds on this case in the past. This is a monetary situation. I will not adjudicate her if she can pay, but there has been no absolute effort to pay since the inception of this case.
Is it court costs, cost supervision, restitution? Can you tell me what she's looking at?
Probation can give you a more itemized list of costs, but very soon, I mean, I think we've continued this at least twice now, and with absolutely nothing has been paid. The state's really close to setting this for inability to pay hearing, VOP hearing.
Understand. May I ask Officer King if she has any insights into how much she's owing and for what?
Well, she owes cost of supervision, she does owe court cost, she does have community service work, and back when she was first placed on supervision, the judge said she was not allowed to buy out the community service work. And then Judge Clark now has said that she could buy them out. But
I was not aware of that. I was not aware that there was a prohibition on buying it out.
Yes, ma'am, this was done a while ago.
You mean there was an express prohibition that may not be bought out?
Yeah, that was
put
on,
in the agreement?
yes, that was on our orders a while ago. You know, she's my case, so, you know, she's been working here and there, but, I mean.
May I ask a question, Your Honor?
Sure.
Officer King, to help her. A lot of times, if everything else is resolved other than the cost of supervision, do you know if those were waived by any language? They were not waived?
No.
But other than that, it's court costs, and what was the other thing?
Well, there's court costs,
And the community service hours.
well, yeah, I mean, we have court costs, we have 2 cases of court costs, we have 2 cases of PD fees, $250 each. We have another 200, we have another 350 because that was brought over from another case that terminated into this case. We have a $65 drug testing fee, $2 per month for each month that she's on supervision, and cost of supervision for $1,440, which is totaling out to $4,175.60.
Thank you, ma'am. May I ask my client?
Yes.
She's wanting to know, is there a way through the clerk's office to have sort of a payment plan option, or is it all done through probation pursuant to, basically it's lump sums that are owed? I don't know that there is a means for clerk to set a payment plan at this point in time. I think it's up to the good graces of the court and the state to give her more time if more time is available. And the state is saying it's done with waiting and wants a VOP ability to pay hearing. So I don't think there is a role for the clerk's office. I mean, that's what she's asking.
Just for the court's record, she is past term, so
Yeah.
we are not supervising her.
To my knowledge, there is no role for the clerk to answer her questions. So we're going to, I think, unless she can make some representation that satisfies the state, I think it needs to be set for ability to pay hearing, and she can talk about what she is paying. It seems like, is the state seeking an adjudication as a convicted felon? Is that a key issue?
Right, if these costs are not paid, she's been given 2 withholds in the past. I've continued this case a couple times for her to at least start making efforts to pay. and not a single dollar has been paid. So yeah, the state will be seeking an adjudication of guilt.
But it's quite possible the state wouldn't be seeking incarceration. It's really coming down to whereas incarceration, is that part of the state's offer?
The state doesn't have a final offer at this moment. I just know for a fact I'll be seeking an adjudication out of VOP evidentiary hearing, because I mean, at that point, it's up to the judge to sentence her.
Looks like there was a previous payment plan entered in 22 CF 1606. I'm looking at it in the court file. It was filed on December 1st, 2022.
But I was told that I couldn't pay through the court. I had to pay through probation.
Okay, well,
You know, I'm just standing here, I can't.
I know, you haven't even, you were just freshly appointed.
Say that we have a resolution pending, other than the state has the right to go forward.
So let's schedule that evidentiary hearing then. How about May 19th? At 9 o'clock?
Your Honor, just so the court's aware, I don't think Mr. Medina is going to be available that week.
Oh, yeah, I'll be not available.
Okay.
There are 2 weeks where I will not be available. That's part of, thank you, Mr. Gates.
Sure.
May 19, yeah. I'd have to do it after like June 1st.
How about, well, we've got June 16th.
That's fine, for me.
Okay, how does that look for the state?
The state's available, Your Honor.
June 16th at 9 o'clock for a VOP evidentiary hearing.
It seems like it'll be focused on ability to pay. Because that's the sole ground of, it's non-payment type issues.
Yes.
May I just have 1 second with her?
Sure. And Ms. Byers needs to fill out the application to make sure she can have a court-appointed lawyer.
Oh, I'm sure she can, but Your Honor, I'm handing her the application. Would you please sit down before you leave and fill it out and provide it to me so I can make sure it's complete? Does she need a new address form too, just to be sure?
The address on record is 618 Gap Creek Drive.
Yeah, that's correct.
Okay,
Number
thank you, Your
34,
Honor.
okay, that's what's in
Fill that
there.
out and give it to me. Thank you. Before you leave.
All right, thank you. So on both cases, that would be June 16th at 9, VOP evidentiary hearing. All right, Mr. Gates or Mr. Medina, would you like to start calling your cases?
We can, Your Honor.
All right.
Your Honor?
Yes.
I've got a witness here for one of the hearings.
Oh.
If we can call that case.
Okay, which one?
This is Willie Davis.
Okay. Let me just get to that one. So I believe we're going to call Willie Davis first, based on the state having a witness present.
Okay. Yeah. Your Honor, that's. That's my client.
All right.
I wasn't sure when that would be.
Okay, that is case number 25 CF 1708.
Your Honor, I'm gonna have to set up my DVD player.
Okay. We're here on the defendant's motion for adverse inference jury instruction, and Mr. Davis is present.
Kind of thinking this would be the last of the day and not in the middle of it, Judge, I'm sorry, so I was, So, Your Honor, just for status purposes, I did file this motion for adverse jury instruction. We're not set for trial this cycle. I have an outstanding subpoena duces taken for records directed to basically the LLC that owns the Slim Chickens restaurant. So there are issues of records that we're seeking that we may or may not get. The return date on that is April 30, 2026. It may or may not provide some information that hasn't previously been provided related to our motion that's before the court. When we were here last week, we addressed the court at the bench, and I indicated that if the state wanted more time, I was concerned that 15 minutes wouldn't be enough on the calendar today. But basically, what I think we need to have is an understanding of what the issue is, and I think I can make that apparent through a DVD that has on it for the state and for the court and me, basically the surveillance video that Slim Chickens produced. The state produced 3 Slim Chickens videos, and you can see very clearly on the Slim Chickens videos that were produced that the Slim Chickens had a video that applied to what they called cooler. But basically, it was the hall area where the alleged criminal act occurred, if it did occur. But that is very apparent. It would take only a couple of minutes to see what the issue is. I am not intending to introduce this for trial purposes, but merely so that the court can understand what the issue is. So I would like to, and I'm sorry I didn't discuss this with my colleague, Mr. Ferris, but basically, the state knows the 3 surveillance videos that it produced. I would like to have this marked as Defendant's Exhibit A and briefly show it to the court. I'm also mindful, like I said at the podium at the bench, if the state needs a continuance because it wants to produce the Slim Chickens general manager who's involved here, I wouldn't have any basis for objecting to that because it was such a short time frame. May I get this marked?
Sure, I think Mr. Ferris might.
Yeah, we certainly don't have any issue with marking the videos that the state's produced. With respect to the general manager, he's here. He's spoken before, testified before the court before, and he's ready to testify specifically with respect to the video, where cameras are, where they are not. That is the
Okay, well, that's fine.
Okay.
I don't anticipate that being a particularly long testimony.
Okay, well then, may I go ahead and introduce this to evidence for purposes of this motion only? It's not talking about trial evidence, Defendant's Exhibit A. May I approach the court?
Yes, you may. And is there any objection to the DVD?
No, Mr. Medina?
Yes.
This is all 3 videos?
All 3 surveillance videos.
Okay.
Any objection?
No, Your Honor.
All right, Defendant's Exhibit A is admitted.
Thank you.
Sure.
I thought I recognized the gentleman back there, I'm sorry.
Okay.
Your Honor, can my client sit down? Because this may take a few minutes. Is that okay?
Sure.
Can he sit at the middle chair? Is that okay?
Is there any, might not need to move some stuff? Does court security need to
Stand up the whole time?
make sure that it's,
Sorry.
Yeah.
Okay, just sit in the middle chair, please. So what I would propose to do, Your Honor, because there's no objection to the surveillance videos being viewed, is I'll just publish them serially.
Okay.
So the court can see them all. And I'm going to pause a couple times. I'm not trying to narrate them, but I will pause a couple times to make a couple of points, basically as placeholders for closing argument.
Okay. You tell me.
And they, you know, it is, of course, it's entirely possible we'll discuss this when the witness testifies as well, but this is sort of laying the foundation for what I'm talking about.
All right. So you tell me when you're ready, and I'll turn on the screen.
And I think I need to hook things up in a way that I'm not real good at, but I think I need to take this
Yes.
thing and, so we've got two things going. I've got a DVD thing and may run out of portals here. I guess I basically need to put it. Sorry.
Judge, that's 2A.
Okay, thank you. And I won't
Okay,
turn it on
good.
until you're ready. So you tell me when you've got what
I'm just
you,
going to minimize my email account, which nobody needs to see.
so when you're ready, whatever it is on the screen on your computer, you tell me, and then I'll put it on the big screen, but I won't do that until you tell me.
Yes, bear with me, please, Your Honor. Sure. Just one moment. I'll get my DVD player up here. Okay, so Your Honor, I intend to basically show these three videos. They're both that like 30 or 40-second videos at the most.
You ready for me to put it on the screen?
Yes, Judge, and
Okay.
if you can put it on the screen.
There we go.
Okay, we're on the screen, so I don't know the volume of it matters because there is no volume.
Okay.
It's just video only.
Okay.
So this is the first of the three, Your Honor.
Okay.
And I'm gonna have to move my screen around. I may have to start it more than once, but
That's fine.
this is when you need a teenager in here. But, Your Honor, this is the defendant allegedly coming through the front door of the Slim Chickens.
Okay.
And I need to start it over when we're,
Sure.
when
Go
we're
ahead.
mindful of everything.
Okay.
So I'm starting it over from the 0 point now that it's maximized. And I don't know, I've paused it, Your Honor, there are 4 quadrants, as the court can see.
Yes.
And may I approach the
Sure,
screen here?
sure.
Just, I don't have a pointer, but the 4 quadrants, the upper left is entrance. And you'll see in a couple of seconds, that gets maximized. The bottom left quadrant is Slim Miracle Cooler. And that is, I believe, the area that includes the office, and I think that might be the assistant manager. I don't see the general manager, but basically that gets minimized,
Okay.
never to appear again. There are other videos that are going to show kitchen and the back door areas, but the cooler never gets maximized. And the question is, was it saved? As far as I know, it wasn't. It certainly wasn't produced. May I go ahead and finish playing
Yes,
it?
go ahead.
So that is the first of 3 brief surveillance videos. I'm going to the second one. May I proceed, Your Honor?
Go ahead.
So this one, the kitchen got expanded.
Okay.
You see the defendant allegedly walking through the kitchen. It ends with the defendant proceeding to the back door. And now I will play the third and last surveillance video that's been produced.
Okay.
That will expand basically the back door area, and you'll see the defendant come out the back door. So that is all I needed to publish as far as the 3 videos. The only other thing
I'm turning off the big screen.
that may be turned off if that's okay. I'm just looking for one other thing, Your Honor. May I have your indulgence for a second?
Sure.
Your Honor, what I'm looking for is, I know the state produced a couple of screenshots of the defendant basically at the entrance door and in the kitchen area, allegedly in possession of a knife. And I can't find those basically black and white screenshots at the moment, Your Honor, that were produced to us. But basically, as I understand it, the general manager did a couple of screenshots, maybe more, I don't know, but basically that were produced to us, in essence, I guess it's done on the computer somehow to circle the hand of the defendant and an alleged knife. And that was the only other thing I wanted to show the court. It may come out in testimony, but that's basically the foundation that I wanted to produce for the court to at least initially understand what I'm talking about. Thank you.
Thank you. All right.
May I, does the state want to access that video some more, and I'll just leave it in the
No, I've got it.
Okay, so Your Honor, I'm going to go ahead and inject that, and just so I don't walk off with it, give it back to the clerk.
Wonderful, thank you.
Thank you. Thank you for your indulgence.
Sure, I mean,
courtesies.
that was helpful to see what the issue is. Okay, all right, so are you finished with your initial presentation?
Yes, Judge.
Okay, go ahead, Mr. Ferris.
The state will call Mr. Donald Whitten to the stand, please.
Okay,
And Your Honor, Commissioner, first, Blackman.
yes, yes. Swear or affirm the testimony you're about to give will be the truth. If so, say I do. Thank you. Just have a seat, get situated, and then state and spell your name in the microphone.
Your Honor, may I, just before he starts,
Yeah.
is it okay, do I have permission from courtroom security in the court. Can I provide the defendant a pad and a flare pen to take notes?
As long as court security is okay with that.
Good. I'm just handing them these two pads.
If you would get close to the microphone and state and spell your name.
Donald Witten, DONALD, WHITTEN.
Thank you. All right, Mr. Ferris, whenever you're ready.
Thank you, Your Honor. And if you'll indulge me as well, I'm also going to be attempting to use the
Okay.
AV for the first time, so
Tell
I think I'm
me-
plugged in.
All right, so you ready for me to put it on the screen?
Not yet.
Okay, you tell me when, and then I'll turn it on.
Okay, thank you. Your
Okay.
Honor. All right, good morning, Mr. Witten. I know that you've testified before this court before at the pretrial detention hearing. I'm not going to be asking you to rehash everything. However, I specifically want to ask you with respect to, well, first of all, what is your job title and where you work?
General Manager.
I'm sorry?
General Manager of Slim Chickens.
And where is that Slim Chickens located?
On 98, 131 Miracle Strip Parkway.
I think you're going to need to speak up and speak a little slower so our court reporter can be sure and hear you clearly.
Yes, ma'am.
Okay?
It is on 131 Miracle Strip Parkway.
That's a restaurant?
Correct.
And are you familiar with the defendant, Willie Davis?
I am.
Do you see him in the courtroom?
I do.
Can you identify an article of clothing that he's wearing?
Orange jumpsuit.
Your Honor, can the record reflect that he's identified the defendant?
The record will so reflect.
And how,
Is there any way that he could lift up the mic a little bit, just change the angle to make it a little easy? Thank you.
Thank you.
and how are you familiar with the defendant?
Former employee.
A former employee?
Yes, sir.
Was the defendant in your employ at Slim Chickens on September 11th, 2025?
Yes, he was.
And do you remember there being an incident involving the defendant at Slim Chickens on that date?
I do.
Can you tell me, again, briefly about that incident? I know we don't need to rehash the whole thing, but briefly about what happened.
Briefly.
Let me interrupt for a minute. The court has a clear memory of the testimony
Okay.
at the pretrial detention hearing. If we could just focus on the issue of the motion about the videos. Okay, thank you.
Mr. Witten, does Slim Chickens have a security video system that covers part of the inside of the Slim Chickens restaurant?
Parts of the inside, yes, sir.
What was that? I couldn't hear that, I'm sorry.
Yes, parts of the inside of the building.
And who at the restaurant is responsible for managing that system?
There's no one that manages the system, but as far as access, I'm the one in the building that has the access.
And this may go without saying, but as the general manager, are you familiar with the interior layout of the Slim Chickens restaurant?
Yes, sir.
And are you familiar with where the interior security cameras at the Slim Chickens are located?
Yes, sir.
And in what direction those cameras are pointed?
Yes, sir.
And was there security footage that captured some of the incident you've described, or some of the incident that happened on September 11th?
Yes, sir.
Did you personally retrieve that footage?
Yes, sir.
How did you retrieve it?
Through our CCTV application.
Is that an application like on your phone?
Yes.
Okay. And you saw the videos that Mr. Medina showed to the court previously?
Yes, sir.
Are those some of the videos that were provided by you to the police?
Those were some of the videos I provided.
Do you remember us meeting on April 10th of this year?
Yes, sir.
At the restaurant?
Yes, sir.
And I took some photographs. Do you remember that?
Yes, sir.
Your Honor, if I may approach the
Yes.
Madam Clerk.
May I just ask the state, Your Honor, to clarify, were these the photographs that were attached to a recent amended discovery exhibit?
That's correct.
Okay. Your Honor, so there, are these the same photos or added to, or?
Those are the same photos that were sent with the discovery.
Your Honor, I do not object. Again, it's for purposes of this hearing today.
Correct.
We're not talking about trial.
Correct.
All right, if I, Your Honor, if you can give me access to
Okay.
however that works.
All right, hopefully it's going to come up. Are you plugged in to the cord?
You may have to go to the, you may have to.
It does, yeah. I can get one. Or I can just do it try it over here.
Not yet.
And you look without picture. Use a monitor.
Hold up the Elmo, I don't know if it's still called that. Shows you what that is. Docket.
Okay, let me get that going. I am pressing the button and nothing's happening, so let me try to.
It looks like it's trying to load up.
Oh, okay, let me try it again. It worked a second ago. I'm going to reboot the system. Okay.
Your Honor, I can also just show these to you.
It did something on the screen, it's just not,
Which is, because I have, Your Honor, I have no objection if the state wants to just publish them directly to Your Honor by hand link
That's
in a
fine.
copy.
yeah, I can't get the thing to come back on.
And I have a black and white copy that I just got that I'll be able to let the defendant look at.
Okay. Yeah, sorry, it's not working.
No, Commissioner President.
Yes, of course, go ahead.
Mr. Winton, do you recognize what's depicted in that picture?
I do.
And what is depicted in that picture?
Has this been, excuse me, has this been marked for identification?
I've handed a disc with all of those photos to Madam Clerk and marked it as Exhibit 1.
Okay,
I believe without objection.
Based on the state's representation, that merely has a digital version of what he's handing the witness. Is that correct, Mr. Ferris?
Yes, Ms. Medina.
so it's composite Exhibit 1, it has multiple photos and things on it?
Yes, Your Honor.
Okay,
No objection, Your Honor.
all right, so then state's Exhibit 1 composite is admitted?
All right, Mr. Winton, what do you understand that picture to depict?
This is the area right behind the front counter, which is also near the front entry. It's the expediting area from food coming from the kitchen to the restaurant. It's short little hallway.
And you're depicted in that picture?
I am in that picture with my back to the office.
And is that where you allege that the incident occurred with the defendant?
Yes, sir.
In that hallway?
Yes, sir.
And that doorway that you're standing inside of, that's your office?
That is the leadership office.
Do you mind handing that picture, Your Honor?
Thank you. All right.
And without belaboring the point, are there any cameras, surveillance cameras, that are pointed at that, in that direction of that?
No, sir.
Are there any cameras at all that capture anything that happens in that interior hallway there?
Not in that hallway, no.
During Mr. Medina's proffer opening, he indicated that there was, in one of the videos, there was 4 separate images, videos that were showing. My first question is, are there only 4 security cameras that capture the inside and the outside of the restaurant?
Negative.
There's more than that. How many? Do you know how many there are?
Approximately 15.
And none of those cameras capture that hallway?
Not that particular area, no, sir.
Mr. Medina referenced a camera that was called Cooler, I believe.
Correct.
Does that Cooler camera capture that hallway?
Negative.
Is that true today?
Correct.
Was that true on September 11th, 2025?
Yes, sir.
Has there ever existed any video of that interior hallway that captured anything that happened on September 11th, 2025?
No, sir.
I have no further questions, Your Honor.
All right, Cross?
Your Honor, can I see what?
Yes, of course.
May I approach?
Of course, here you go. Thank you.
Good morning, sir.
Morning.
There was a video marked Cooler. Why didn't you produce what was on that video marked Cooler? Did you produce that to the state?
Which question you wanted me to answer? Right. Cooler or, there was nothing in the cooler area to
There was a
produce.
quadrant, bottom left-hand corner, marked Cooler. Did you preserve that video?
No, sir.
Why not?
It wasn't relevant. I wasn't asked to.
You gave a deposition a couple weeks ago to me, right?
Yes, sir.
And you indicated that the door that you were in was the office door,
Correct.
right? And that's this door.
Correct.
Is that a different door than the assistant manager was coming out of in Cooler, the Cooler video?
No, sir. My assistant manager wasn't in that area. It wasn't in the back. The cooler's in the back of the building. The office is in the front of the building.
Okay. So that wasn't your assistant manager in that Cooler area?
You'd have to point. My assistant manager was in the front of the building. I had a shift leader that was in the back.
Okay, Judge, may I have that back?
I'll do my best to get it going. You mean the video or?
The video, I gotta do show the video again.
Okay.
Can I have Defendant's Exhibit A?
Oh, it's working. The screen is working now.
Sorry.
Okay. I'm turning it off so that you can get set up, and then I'll turn it back on. And hopefully it'll work then.
Your Honor, I've just reloaded Defendant's Exhibit A.
Okay, I'm turning
It may
on.
take a moment for the...
Oops.
It looks like that's my computer, so I think I'm going to be able to pull it up here.
Do you want me to turn off the screen while you do that?
No, it's fine, Your Honor.
Okay. All right, so this is Defendant's Exhibit A again?
Yes, and I'm
Okay.
pulling up just for the first video, sir. Okay, so that bottom left-hand cooler video, that quadrant. Okay.
Okay, yes. That is my assistant general manager walking from the back. That is dry storage and also leads to an exit door to the rear of the building.
She appears to walk out of a door. What is that door she's walking out of?
It's a walkway. It's not a door, but it's a walk-through, and in back there is dry storage, chemicals, boxes with tea, paper goods.
Okay, so that door in the bottom left-hand corner, is that a different door than the door that's you're
Yes, sir, it's a different door.
Okay. So
Opposite
there
ends of the
is-
building.
There is no video of this hall.
No, sir.
Okay, so that, when you remember when you gave me a deposition and you did a drawing?
Yes, sir.
Let me see if I can find the drawing. Mr. Ferris, you don't have to have your copy of that drawing, did he make?
I have it on my computer.
Oh, no, that's okay. I'm sorry, Judge, may I have your indulgence? if I
Sure.
Pull it out.
Sure.
Okay. Your Honor, could I have this marked as Defendant's Exhibit A, B?
No objection.
Okay. And Your Honor, may I?
Yes, yes, so this will be Defendant's Exhibit B, and are you offering that?
For just, for evidence in support of the motion.
All
No
right.
objection to the state.
All right, Defendant's Exhibit B is admitted.
Okay, thank you.
May I add something? What you see in that bottom right quadrant is that doorway that you're asking about on the bottom left.
The one that says camera one?
Correct. That is the angle of that door, what's behind that doorway you're questioning.
I'm not understanding what, I see a camera in the bottom right-hand quadrant.
That angle, yes, sir, is behind that door of the bottom left that you were asking about, where my assistant general manager had walked out of. That is the dry storage area. That bottom right view is the view behind that door that she walks out of.
Okay, so the cooler door she walks out of is not the office door.
So it's titled, no, sir, it's not. It's titled cooler door because just beyond the bag-in-the-box system that's there is the cooler door. But that doorway that she walks out of is the dry storage area that is depicted in the bottom right quadrant.
Okay, Your Honor, I'm going to speak this up here real quick.
Go ahead.
If there's not a dispute, we're going to find out. And I
Okay.
apologize, I'm doing my best.
Go ahead.
May I approach?
Yes, yes, you may.
And I will represent, there's highlighted, accidentally this was left on the table, so you didn't make that mark that's marked and highlighting, another witness did, and the state was there when that happened. So we highlighted it so you wouldn't think you drew that line.
Okay.
But otherwise, this is your drawing you made in your deposition, correct?
Yes, sir.
Okay, so, but coincidentally, though, where that line is that is highlighted, that's That's way in the back. Your office is up here, you drew and wrote lobby and office, right?
Along with front counter,
Front counter.
expo window, kitchen, and then I said back here is storage area, cooler.
Okay, so on your drawing that you made, can you show me, and then I'll see if I can show the court, but can you show me on this drawing where the cooler camera is?
It would be much further back here. It's not in that drawing anywhere. I was just trying to give you the entrance and the path walked in.
Okay, so there is no, your testimony, there is no video whatsoever between what you marked as office and window on your drawing.
Correct.
Okay. Your Honor, may I?
Yes.
Provide that to the court?
Thank you.
And Your Honor, I'm proceeding in good faith. When issues come up, I'm always owe a duty of candor to the court. The witness has clarified something. When you have jury trials, you try to file, I try to not wait to jury review to identify potential motions in limine. I'm going to withdraw that motion in limine based on what he has provided. When I filed it originally, I didn't know when the trial was going to be. We also had have a subpoena that's still pending. I don't know what I'm going to get in response to that. Had I had all of that and known we were going to be carried over to next cycle, I might have been able to clarify this earlier. So I do apologize for inconveniencing the parties, but I'm going to withdraw the motion in limine for now. It's without prejudice should I need to refile.
Okay.
But we don't need to take further time on it right now.
Your Honor, if I might, I just for Mr. Medina, the layout is a little confusing of the restaurant, and until you sort of see it personally, it doesn't all make sense. So it is a little confusing as to which door is which door.
And Your Honor, for the court's awareness, is when we do these depots, obviously I'm not the most technically savvy person, but the witness is in a little room at the public defender's office.
Oh, wait, he needs to stay back up. Oh,
Stay right here, yeah, you want to go.
okay.
Yeah, so anyway, I didn't have a laptop access to a laptop while we're doing the video doing the deposition into the same computer. So I apologize for not clearing this up earlier.
No, I mean, I can see the confusion.
And Your Honor,
That could result.
the next court date for him is going to be June 10th.
I believe so. Let me just take a look. Oh, yes.
Yeah.
Thank you, sir. You're
Yes,
free to
ma'am.
go.
Thank you.
June 10th at 9 o'clock for pretrial conference.
Right. Okay.
So that's our next court date. Is Mr. Davis, can he return? Are we done?
Yeah, we're done with
Okay,
him for
thank you, Mr. Davis.
And Your Honor, I'm returning this photograph to do you want those to go
This
to
is
the
just the
court, or
copy.
you?
The
or it's
clerk has
just a
that.
filler for the DVD, right? So that
Yes,
goes
that-
back to you, the state.
Okay,
Thank you.
sure. I'm going to give you this paper order to fill out. So that the record is clear. So, Mr. Medina, if you want to come take this, you can fill it out and write on it. The motion was withdrawn during the
Yes.
hearing. There you go, I started
Thank you
it,
so
but
much.
thank you. If you'll just fill it out, that way the court record is clear that the motion's not just hanging out there unheard.
Your Honor, may I write stipulated withdrawal?
Of course.
By defense?
Sure, whatever y'all agree upon is fine, just so that
Stipulated
there's,
withdrawal by defense without prejudice. That's what I'm going to write.
Sure.
yeah, that way the court record is clear that the motion was addressed. And it doesn't appear that the motion has been not heard or ignored. All right, so I see Mr. Koch coming. Mr. Koch, would you like to proceed? I don't see, I guess Mr. Gates is probably talking to you.
Absolutely.
All right, go ahead.
Absolutely. All my people are in custody. Yes. Yeah, and I'm gonna.
Don't forget Mr.
No.
Oh, that's right.
Your Honor, may I proceed that order?
Thank you.
Thank you.
Thank you so much. Here we go.
Mr. Medina, I'll take that DVD whenever you're ready.
Oh, yeah. Sorry.
Oh, don't apologize.
Negative.
Judge, first up is going to be Troy Dowd. Sorry.
All right.
Excellent.
Your Honor, may I approach the court?
Yes. And here is an order. Thank you.
On the rest today. Troy down, we're ready on this crowd. Absolutely.
Good morning.
And Judge, this is Mr. Troy Dowda, here on two case numbers, 24 CF 2153, 24 CF 2281. If I may have a brief moment for a signature, Your Honor?
Sure, go ahead.
Okay. So, I'm going to have you sign with me. You sign right there for me and date it 4/21. Okay. Thank you.
Thank you.
Okay. So that's your copy. We'll keep it because I'm going to give this to the judge and she will announce the terms. And she gave me the new score sheet. Now you have the 4 years over your head, so that's more than that number, okay? Judge, thank you for that brief
Yes,
moment there.
thank you.
If I may approach, I have a signed plea form. Also, I have a score sheet, no objections.
All right. Thank you very much. Thank you.
You're welcome. Mom's been a big help. She's present in the courtroom.
All right, this appears to be a downward departure.
Yes, Your Honor, this is a downward departure based on a legitimate uncoerced plea bargain. I have been provided some outside facts regarding this defendant and why I'm doing that. If Your Honor needs more explanation, I can approach and explain. There is a suspended sentence attached to this. I've made it clear to Mr. Koch, and I'm representing to this court, and Mr. Dowd is listening, that this is his last chance. That 4-year, the state will be moving for that 4-year suspended sentence on the slightest mess up, if that were to come. A lack of reporting, a positive UA, the smallest violation, this is absolutely his last chance.
Yeah. Usually I'm hesitant. The problem with the suspended sentence is it's meaningless if it's never imposed when there's a violation. So the court would be of the same opinion. And it is quite fortunate for Mr. Dowda that his attorney and the state have reached out an agreement. Otherwise, the court would absolutely be imposing that suspended sentence.
And Your Honor, well, especially at least from my opinion in my cases, I would say 98% of the time move forward. This is a very rare occurrence, at least for me in my cases, where I don't move for that.
Okay. I believe I need to make some specific findings in this case under 948.068E, I believe. And I have the statute handy if anybody needs it. So let me get some information from Officer Keene. Does probation have a concern regarding danger to the community if Mr. Dowda were to be reinstated to a new term of probation?
No, ma'am, I don't believe that we do. The only thing I would eventually inquire when we get to that is where this place is and how he's going to get there.
Okay. All right. So, and I'm looking at the nature of the alleged violation. It's not a new law offense. And sir, what I'm doing is I have to make certain findings. It looks like Mr. Dowda was placed on probation in February of 2025. And this appears to be the first and only violation is the one we're here on, which is one allegation, and it's a positive UA. It occurred about a year after Mr. Dowda was placed on probation. It's not a new law offense. So the court will find, I have considered the factors in 948.068E1. There are 5 factors. I do have to enter a written order on that. So I'll need somebody to prepare a written order. But the court does find, the court has considered the nature and circumstances of the alleged violation, which does not involve a new law offense. Present conduct, I've gone over that. This is the first violation in a year on probation, and it's not a new offense. Amenability to non-incarcerative sanctions based on history and conduct. It looks like Mr. Dowda, if he enters this admission and the court accepts his plea, he will be going into a treatment program, which, Mr. Dowda, if I'm not mistaken, I believe you've requested yourself to go into a program. And those are the facts, and I mean, the weight of the evidence against the defendant, well, we haven't really gone into that because I think there's going to be an admission if we proceed forward on this agreement. But those are the facts that I've considered. I have to enter a written order making certain findings under the statute. So, Mr. Koch, I'm going to need a written order from y'all.
Yes, Judge.
Let me give you that statute number.
Absolutely.
948.068, subparagraph 8E, and then subparagraph 1. And I've also considered, based on the recommendation or the statement made by Officer Keene, that she was not concerned about danger, so.
Yes, Your Honor.
And she is a probation officer. All right, Mr. Dowda, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
Do.
Thank you, sir. You can put your hand down. If you'll just state your name, please.
Troy Dowda.
Thank you, Mr. Dowda. You're here in case 24 CF 2153 and 24 CF 2281. And you're here on one allegation that you violated your probation. I'm looking at the affidavit filed on February 18th, 2026. And a minute ago, I mentioned what that one violation is alleged to be. Have you had a chance to talk to your lawyer about that allegation you violated your probation?
Yes, ma'am.
All right, and have you discussed this agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
I did.
Is that your signature on the second page?
Can't see that far, but I'm presuming.
Oh, I'll have it brought to you, Mr. Koch, if you want to bring it, or,
Thank you,
okay.
Deputy.
Of
Thank
course,
you, Judge.
can. Sure. Is that your signature, sir?
Yes, ma'am.
Okay, great. Thank you. Thank you so much. Do you understand the rights that you give up when you admit to a violation?
I do.
Do you understand you're giving up your right to have a contested hearing and make the state prove the allegation?
Yes, ma'am.
Is anyone forcing you or threatening you to admit the allegation?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Very, I am.
Have you had any drugs, alcohol, medicine, any type of substance in the last 24 hours?
No, ma'am.
I do have a score sheet, and it shows 58.4 total sentence points with a lowest permissible prison sentence of 22.8 months. Any objections?
No objection from defense, Judge.
Okay. And the state already put on the record this was a negotiated, legitimate, uncoerced plea bargain by the state and accepted by the defense, which is the basis for the downward departure. Sir, are you admitting the allegation that you violated your probation?
Yes, ma'am, I did.
I accept your admission. I find it was freely and voluntarily made. In accordance with your agreement, the court finds you guilty of violating your probation. You've already been adjudicated guilty on the charges in both of these cases. Is this a reinstate and modify? Okay.
Yes, Your Honor.
Reinstate and modify to a new term of probation in both cases. That'll be 24 months of drug offender probation, which will have a curfew from 7 p.m. to 7 a.m., followed by 12 months of standard probation. There's a cost of supervision of $40 per month, but that will be waived while you're in the farm program. There's also a surcharge that goes along with that once that kicks in when you're done with the program. You must successfully complete the farm program. This is bars to bed, meaning you have to remain in jail until you get transported to the farm program. So you must successfully complete it. You have to remain there and complete the program. If you are discharged or if you leave the program before you've completed it, that's going to be a violation. You will be looking at that 4-year suspended prison sentence. And then the following additional costs and fees will be imposed. $100 per case, VOP, cost of prosecution fee, $100 per case, cost of defense fee, and a $50 application fee. That'll be applied to the lowest case number, which is the one ending in 2153. You'll still have to complete all of the original terms and conditions, the 4-year Department of Corrections prison sentence. I see that only applies in case number 24 CF 2153. It was just imposed in that one. That will be reimposed. That's still hanging over you in 24 CF 2153. Did I cover everything?
Yes, Your Honor, and if I could just briefly, on the bars to bed for this farm program, Mr. Dowda's mother is present in the courtroom. She's been very helpful. I have not had a client go to the farm program, so I believe they will come pick them up, and they're going to be instructed to, when they pick them up, take them first to probations and then to the program. And if for any reason farm program cannot transport, I'll follow up with my own investigator, so we can pick them up, go to probation, and then to the program.
Okay, that sounds good. Do I need to set a status hearing to make sure that Mr. Dowda gets there?
If we could.
Yes, we will do that. So let me hand these agreements to Madam Clerk. Thank you. Then we're going to set a status hearing for May 19th at 9. Now, the only reason we will have that hearing is if Mr. Dowda is still in jail on that date. So I hope you are long gone by May 19th and you're well established in your program by then. But if you're still in jail, we'll bring you back to court and see what's going on and why you haven't been transported, okay?
Yes, ma'am.
So that's canceled if Mr. Dowda gets picked up and taken.
Yes, Your Honor.
All right. Just writing that down. Status of transport to farm. And you do need to go to probation first. Once you get picked up from jail, you got to go to probation and check in, then go straight to the program.
I
Okay?
actually, whenever I violated on February 12th, I went straight to the farm. They gave me till 5 to be there, and I got there. And if they can't pick me up, you could give me a lot of time to be there. And I know it's at stake.
I'll have someone pick you up, so
Yeah.
we'll, like I said, Judge, if the farm does not provide transportation, I'll, through my office, I'll make it happen.
All right. If you need the court to sign any orders or anything, I'll be happy to do that to help facilitate Mr. Dowda get back to the program.
Excellent. Thank you, Judge.
Good luck, sir. You have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. I wish you the best in your program.
Thank you.
Thank you. See Officer Keene.
You're welcome.
Javion Sharp is up next.
So, Mr. Koch, I will need a written order making those findings. It can be brief.
Yes.
If you read the statute, you'll see what I'm talking about.
Yes, Judge.
Okay, thanks.
Judge, this is Mr. Javion Sharp, who's present.
Yes. All right, let me get to Mr. Sharp's case on the docket. All right, Mr. Koch, I might need a little help finding, oh, here we go. Okay, so we have case numbers 24 CF 1563, 24 CF 1562, 24 CF 1564, and 24 CF 1685, 4 cases. And Mr. Sharp is present. And we are here on the defense's motion to dismiss. And Mr. Sharp has returned from Florida State Hospital, and I did review the report. And let me see what this, well.
Judge, if we may approach.
Yes, come on up.
Mr. Sharp.
Thank you.
If I may approach with that signed plea form, and I have no objection to a score sheet also, Your Honor.
All right. Thank you. Thank you so much.
That will be resolved when you enter this plea form, all your, yep. The same plea form she has, just so we can have it in front of us.
I'm just signing the score sheet. And then I'll ask Mr. Casey some questions. All right, Mr. Casey, whenever you're ready, if you'll just raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you. You can put your hand down. You're here in case numbers 25 CF 786, 25 CF 788, 25 CF 789, 25 CF 790, 25 CF 792, 25 CF 1672, and 25 CF 1927 on allegations that you violated your probation. And I am looking at the amended affidavit that was filed on April 7th, 2026, and it has 5 allegations. And do you want me to read out those allegations, Mr. Koch?
Negative, Your Honor. My client will be admitted to those allegations.
Okay. Have you had a chance to talk to your lawyer about the 5 allegations you violated your probation?
Yes, ma'am.
All right. Have you discussed this plea agreement with your lawyer?
Yes, ma'am.
The plea agreement also includes case number 26 MM 744, which is a new, well, it's 3 new law offenses that are charged, and those are: count 1 is possession of alcohol by a person under 21. It looks like that's a second-degree misdemeanor with a maximum penalty of 60 days in jail. Count 2 is resisting an officer without violence, which is a first-degree misdemeanor with a maximum penalty of up to 1 year in jail. And count 3 is possession of drug paraphernalia, which is a first-degree misdemeanor with a maximum penalty of up to 1 year in jail. Did I get those right in order? Just want to make sure I pulled up the case. Okay. Have you had a chance to talk to your lawyer about those 3 new charges in 26 MM 744?
Yes, ma'am.
All right. Have you discussed this agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand the rights that you give up when you admit to a violation of probation?
Yes, ma'am.
Do you understand that you have the right to have a hearing and make the state prove the allegations that you violated your probation?
Yes, ma'am.
Do you understand you're giving up that right?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea on a new case?
Yes, ma'am.
You understand you're giving up your right to go to trial in 26 MM 744?
Yes, ma'am.
Is anyone forcing you or threatening you to either admit the violations of probation or to enter a plea in your, excuse me, in your new misdemeanor case?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
I do have a score sheet with 50.4 total sentence points, and Mr. Koch, I believe you stated no objection, right?
That's correct. No objection, Your Honor.
Is there any DNA in the new case?
None from defense, Your Honor.
Okay. Is there a stipulation to a factual basis in the new case? That's 26 MM 744. I mean, I'm aware of the case, but I have not reviewed the documents.
Defense stipulates, Your Honor.
Okay. Mr. Casey, if you're not a U.S. citizen, do you understand you could be deported as a result of the plea?
Yes, ma'am.
Okay. Are you admitting all of the allegations that you violated your probation in the amended affidavit dated or filed on April 7th, 2026? I accept your admission. I find it was freely and voluntarily made. And how do you plead to counts 1, 2, and 3 in 26 MM 744?
No contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, the court does find you guilty of violating your probation based on your admission, and it looks like you've already been adjudicated guilty of the charges in those 7 violation of probation cases. Probation in those 7 cases is revoked and terminated, and you are sentenced to 24 months state prison. That is the suspended sentence that was imposed when you originally entered your plea in those cases. That is in all cases, all of the 25 CF cases, there's 7 of them, that's concurrent with credit for time served. And in each of those cases, there is an additional $100 VOP cost of prosecution fee, an additional $100 cost of defense fee, a $50 application fee that will be applied to the lowest case number, which is 25 CF 786. Did I cover all the terms and conditions in the 2025 CF violation of probation cases?
That's everything for defense, Judge.
Okay. And then in 26 MM 744, there's an adjudication of guilt on all 3 counts. You're sentenced to time served on all 3 counts. And let me verify the court costs. Is it $270?
Yes, ma'am.
Okay. $270 in court costs and $100 cost of defense. That would include an application fee as well. So all cases and counts are running concurrent. And what about the fees and costs in all of the cases? Are those going to collections?
Judge, could my client have a year after release from Department of Corrections?
Yes. So Mr. Casey will have 1 year after he is released from prison to pay all of the unpaid costs and fees in all of the 2025 cases that we're addressing today, and also in the 26 MM 744 case. So I don't know how the clerk will keep track of when he's released, because it's not going to prison in that one, but, okay. So it's 1 year after release in all of the CF cases that would be the deadline to pay before they go to collections. And I'm writing that on here. So you have 30 days to appeal the order of the court in each case, and if you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
Yes,
Thank you.
Thank you.
All right, best of luck.
Cameron Cooper's up next.
All right.
And Your Honor, eventually I do have a client in custody at the Okaloosa County Jail. That should be a Zoom.
Oh, yes, I'll have to turn that on, so I'll go ahead and get that going.
Thank you, Judge.
Make sure that I think I said it.
Judge, and this is Mr. Cameron Cooper in 1995 CF 774, Your Honor.
Okay, and he is present?
And
All right.
Judge, may I provide a case number for the new law violation?
Actually, I think I have it, but go ahead.
The 26 CF 641 for the new law violation in this court.
Yes.
And Your Honor, that case is set for arraignments on May 14th. As of right now, there hasn't been information filed. So I'm asking the court today to enter denial in the 1995 CF VOP case and ask to continue this case, and I guess we group them together and set them all for that 5/14 date.
Okay, so Case 1995 CF 744. A denial has been entered, and we will set the next court date in that case to match the arraignment date in the new law case, which is 26 CF 641. It is currently scheduled for arraignment on May 14th at 1:30. So we will set the 1995 violation of probation case on that date as well, so that they will both track together. Okay? So that's May 14th at 1:30 to be heard or addressed in connection with the new law arraignment.
Thank you, Judge.
Thank you. All right.
Next question. Next up is Jeffrey Crump.
And this is Mr. Jeffrey Cronk, Your Honor, 21 CF 2328.
Yes.
And if I may just have a brief moment for his signature.
All right.
This will be admission, ultimately revoke and terminate probation. May I approach with the signed plea form?
Yes.
And no objection with the score sheet.
All right. Thank you. All right. Thank you. Let me go get the score sheet. All right, let me just pull up the case. All right, Mr. Crunk, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you. You can put your hand down if you'll just tell me your name, please.
Jeffrey Dale Cronk.
Thank you. You're here in 21 CF 2328 on allegations that you violated your probation, and I'm looking at the amended affidavit that was filed on December 2nd, 2025, and it contains 2 allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes, ma'am.
Have you discussed this agreement with your lawyer?
Yes, ma'am, I have.
Did you read and sign the agreement?
Absolutely.
Is that your signature on the second page?
It is.
Do you understand the rights that you give up when you admit to a violation?
I do.
Do you understand you have the right to have a contested hearing and make the state prove the violations and that you're giving up that right?
Yes, ma'am.
Is anyone forcing you or threatening you to make you admit the violations?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Absolutely.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
I do have a score sheet. It shows 45.8 total sentence points. Any objections?
No objection from defense.
All right. And it shows the lowest permissible prison sentence is 13.35 months. And sir, do you understand that if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
Are you admitting the 2 allegations in the amended affidavit filed on October 2nd?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made. In accordance with your agreement, the court finds that you are guilty of violating your probation, and it appears you've already been adjudicated guilty on the original charge in this case. Probation is revoked and terminated, and you are sentenced to 13.35 months in state prison with credit for time served. And the following additional costs and fees will apply. $100 cost of prosecution fee, $100 cost of defense fee, and a $50 application fee. And did I cover all the terms and conditions?
That's everything from the fence, Judge.
All right, and sir, you'll have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck, sir. Thank you.
Thank you, ma'am.
William
Thank
Elliott.
you. Appreciate it, State.
All right.
Excellent. This is Mr. William Elliott, 23 CF 338, Your Honor.
Yes.
We're here for a violation of probation, and the state's going to announce a current offer.
Okay. And Mr. Elliott is present. Good afternoon. Or-
Offer is currently 9 months in the Okaloosa County Jail.
Judge, may I just have a brief moment?
Sure.
If I may pass up Mr. Elliott, he would like to accept that 9-month offer, and I can get that plea form ready.
Sure, sure, absolutely. So let me just, yes, we'll pass Mr. Elliott. I need to plan on our lunch break, so I'm going to start asking about who all is in the courtroom before we break for lunch, if anybody's got a case. So we'll call you back out. It'll probably be after lunch. Thank you. Thank you.
Excellent. I'll see you soon. Yep.
So I see several people in the courtroom. If you have a case today and you haven't been called up, if you could please raise your hand and we'll try to take you before the lunch break. Okay, I see some hands. Ma'am, come on up if you would. Or sir, I can't see very well who all's there. If you'll just come on up, I just couldn't see you. Your hair threw me, I'm sorry. You were a long way away, I could not see you. All right, can you tell me your name?
Jawan Gray.
One more time.
Jawan Gray.
Could you spell your last name for me?
Gray.
Oh, thank you, I found it. This is case number 22, CF 1437, and Mr. Gates, I believe this might be yours?
No,
Mr.
Your Honor,
Jawan Gray?
I think what we did is, because it was monetary, we asked the court not to appoint the PD office to save him that money.
Okay.
And then brought him back as a status, and I think the state has something put on the record.
All right, let me take a look. I think this might be our first court date on this case for the alleged violation. And it's a notice to appear, and the issues are court costs and drug test fees. So.
I paid those already.
Sorry?
I paid those like 2 weeks ago.
Okay.
Ms. Jardina has something to say, Your Honor.
Okay.
Your Honor, the state was going to ask if we can continue this to give Mr. Gray the opportunity to pay those off. Can probation confirm?
He has paid off in full. Yes.
Okay, so he has no
Fantastic.
outstanding conditions?
I'm sorry?
No outstanding conditions?
Let me double check that.
Thank you.
No, everything's completed.
All right, Your Honor, the state dismisses the violation of probation.
Okay, so I'm looking, it looks like you've got a little bit longer to go on probation before you're terminated, is that
I was
correct?
supposed to get off on the 19th.
Oh.
No, ma'am, he's actually past term.
Oh, great, okay. So state is dismissing the violation, and sir, your probation is considered successfully terminated. Thank you for paying off those costs and fees.
Thank you.
And you're free to go. Thank
Can
you.
I get paperwork? Oh, something saying that it's terminated?
There will be an order that probation's going to send me and I'll sign it, and then you'll get it from your probation officer.
All right. Thank
Okay?
you.
Good luck, sir. Thank you. Anyone else in the courtroom with a pending case? Okay.
I know, Your Honor, I don't see him in the courtroom, but I know Mr. Boyd is here. I saw him, he might be in the hallway.
Okay.
But I know he's present, so.
Okay, so let me see if Mr. Medina wants to take him, and then we're going to take our lunch break, because I know we have a lot of cases left, so we ought to take a lunch break.
Are you referring to Boyd?
Yes.
Yeah, he's out in the hall with his family, Your Honor, may I go get him?
Yes. While you're doing that, I'm going to address another case. It's not on the docket, but I had it in my notes. This is Richard Harter, Harter, 23 CF 2802. And Mr. Harter was on our docket on April the 2nd, but there was an issue with him not getting notice of the hearing, so it was reset for today. But the probation officer that was in court that day, and I don't remember who it was, said that a warrant was coming, but I haven't gotten one. So that's
Who was this on, I'm sorry?
Richard Harter, Harter. It was a notice to appear, and it was set on April 2nd. And on that court date, he had not received the notice to appear, so he hadn't gotten notice. So we passed the case and reset it for today. It's not on the docket, but it's in my notes that it was reset for today. Yes, yeah. So there's no attorney assigned to Mr. Harter's case yet because he hasn't appeared before the court on the violation allegation. So really, I'm just letting probation know that on April 2nd, on the court date, it was, whoever was in court for probation stated a warrant was coming, but I just haven't received one.
I think it was Officer Perez, if I remember correctly, Your Honor. But she said he was in scholar status at
Okay.
the time.
So I haven't gotten a warrant, so he was in my notes and the clerk minutes sheet for today, but he hasn't gotten notice of today's
I'm
hearing.
going to email his officer, which is Ms. Hernandez.
Okay.
I'm emailing her right now.
Okay, I just wanted to address it since it was on the clerk's minute sheets for today. Okay. Thank you. That'll take care of Mr. Harter until that paperwork is taken care of. All right.
Steve Medina with Jonathan T. Boyd. Mr. Boyd is approaching. He has, I believe, family members in here. Are these your two sisters? One is your sister?
Yes.
All right.
And 25 CF 2044.
Yes, Mr. Boyd is present, and
Your Honor, we're here basically for status, to give him an opportunity to put on the record his decision as to the state's offer. Before we do that, would the state please advise on the record the state's best offer and also the state's position if he does not take the state's best offer?
State's best offer, as of now, with the information that is filed, is the minimum mandatory sentence of 3 years, Department of Corrections. If Mr. Boyd does not accept this offer today, given the FDLE results that have come back with a mixture containing fentanyl of 19 grams, the state will amend the information today with the trafficking in fentanyl as count 1, 14 to 28 grams, which then holds a 20-year minimum mandatory. The state's offer will then be at that point 20 years.
And Your Honor, the only thing that I need to put on the record before perhaps the court would want to do a colloquy with the defendant, but yes. I'm not going to reveal the contents, but I did, the day that we had the hearing that resulted in him getting a signature bond was April 16th. The following morning, I composed a letter. It was hand-delivered to him at the jail on April 17, 2026, with confidential information giving him my evaluation and recommendation. So he's had that for 3 or 4 days in his possession. So at this point, I think the court probably needs to inquire of the defendant.
all right. So, Mr. Boyd, if you'll just raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down, and if you'll just state your name, please.
Jonathan Boyd.
Thank you, Mr. Boyd. So you're here in case 25 CF 2044. At the moment, I'm going to read your information. At the moment, you're charged with, as soon as it loads, and my computer is now loading. The current information filed on December 3rd, 2025 shows 1 count of trafficking in cocaine, 28 grams or more but less than 150 kilograms. That's a first-degree felony. It carries a maximum penalty of 30 years in prison and a minimum mandatory sentence of 3 years in prison. Then count 2 is resisting an officer without violence. That's a first-degree misdemeanor with a maximum penalty of up to 1 year in jail. Count 3 is possession of drug paraphernalia, which is a first-degree misdemeanor with a maximum penalty of up to 1 year in jail. And count 4 is tampering with evidence. That's a third-degree felony with a maximum penalty of up to 5 years in prison. And if my math is correct, if you were to be tried on those 4 charges and found guilty on all of them, you could be facing a maximum sentence of 37 years. Is that right, Mr. Medina and Ms. Gaynor? If everything was run consecutive, back to back.
That is the math, Your Honor. I would note that the misdemeanors are not included in the final maximum sentence on the score sheet. It includes the first-degree felony, count 1, 30 years, and then the 5 years for count 4. But Your Honor is correct that technically it could be 2 more years for the 2 misdemeanors as well.
So do you understand the current charges and the maximum penalties that could be imposed if you're convicted?
Yes, ma'am.
All right. And the state just put their current offer on the record. Did you hear the state's offer?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Okay. Do you need any time to talk to your lawyer other than what you've already had? You need additional time to talk to your lawyer about what your decision would be?
Right now, Judge, at this point in time, I feel like Mr. Medina is not the best of my interests. As an attorney, I would like to have some time to get an attorney. I've been in jail for 6 months. I've been out of jail since Friday afternoon at 5 o'clock. And I need to speak with an attorney about taking my case. And I just want to ask the state, is the deal still on the table for the 3 years? If I was to get rid of Medina and find an attorney. And also I have some paperwork for you from DeVita.
From?
DeVita, the treatment center for
Okay.
dialysis.
Okay, that's something you probably need to file with the clerk.
This
So
here?
if you want that in the court file, I'm not sure what it is. Mr. Medina, have you looked at whatever that is?
I have not looked, Your Honor.
Okay, you might want to show that to Mr. Medina before you file it with the clerk. I have no idea what that is.
Okay.
So,
May I have a moment, Your Honor?
sure.
Your Honor, may I have a moment with him?
Yes.
Have a moment with the state?
Sure. Yes.
This letter, I've shown it to the state. It does have confidential medical information, but I would ask if it could be filed with the court. I don't think there's any objection from the state, and have the court declare it to be confidential record so that we don't have to follow up with this. Maybe I do have to follow up with a separate
Let me ask
filing.
you, if the court were to accept the letter and deem it to be a confidential filing, would a motion or order also have to be filed if it's accepted? And what does the clerk need?
Should be able, mark it as non-public, and then we just move. We have to do it to get it into our system under a separate, so it wouldn't be public.
Okay. Okay, so they can do that without an order? They will put it as a non-public document?
Thank you, Your Honor.
Okay.
I'm, just for precaution, I will leave it in the same envelope that he provided it to me. There with the sticky on the front, letter for J. Boyd with the envelope, and may I approach? with
Sure. Sir, you want me to file that with the court?
Yes, ma'am.
Okay.
And it'll be confidential.
All right. And in case I didn't already announce the case number that we're here on, it's 25 CF 2044. And so, I'm just looking at it. Okay. I will hand this to, do you need the envelope?
I don't think
I'm
we
going to
need
hand
the
you back the
envelope.
envelope.
Sorry.
And I'm just going to give,
Sorry.
that's okay. So I'm giving this to Madam Clerk. And that would be a non-public, confidential document. There is a basis since it concerns medical information. So regarding,
Your Honor, may I?
Yes, go
Something
ahead.
else. Did the court complete the colloquy?
well, I need to ask Mr. Boyd. I think Mr. Boyd had a question about whether the state would leave their offer open, but do you understand, before we get to that, do you understand, sir, that the state, what Ms. Gaynor stated about she's planning to amend the information to charge you with a different offense on count one because of what she said about the FDLE? Do you understand what she said?
Yes.
Okay, and that particular offense, if the state does in fact amend their information, Ms. Gaynor's representing, that one has a 20-year minimum mandatory. You understand that?
Yes, ma'am.
Okay, so, go ahead, Ms. Gaynor.
Your Honor, I'm trying to give the defendant the last opportunity to do this. I'm not trying to blindside anybody. You know, I personally think that would be unfair to go from 3 to 20 years with no kind of heads up, especially given Mr. Boyd's circumstances. So that's why I emailed Mr. Medina, a week or so ago before that Thursday hearing last week, and then I also gave them more time over the weekend when he got out on bond to discuss it with his family and get any kind of affairs in order. Even if he does hire a private counsel or anything like that, the state's offer isn't going to change. I can't change it. The legislation and the statute says it's either a 3-year minimum mandatory, or if I amend the information, it's a 20-year minimum mandatory. I have no control, and this court has no control to change that minimum mandatory sentence.
Your Honor,
I'm just
can I
not trying to blindside anybody on that.
Can I put a couple more things on the record?
Sure, go ahead.
Number one is that I do want also the court to be aware that I reached out to Assistant State Attorney Gaynor because knowing that he was going to be getting out on a signature bond, knowing that he was going to be coming before the court for status today. And basically I asked a hypothetical question. Were he to agree to a plea and sentence agreement with a 3-year minimum mandatory, would the state agree to set off sentencing so that he could get his affairs in order, talk to his children and grandchildren and so forth, until the next pretrial? I know the next pretrial would probably be on Monday, so it probably would have to be adjusted a little bit. But basically the state was open to a deferral of sentencing into the next pretrial period.
I would accept that. If you put a plea in today, we could set off sentencing for another date.
So that was part of what I did advise him in writing about. The one clarification was I had told him the state had agreed that it could be held open till June 8th pretrial conference at 9 a.m., but he would be getting kidney dialysis at that time, so I think it would have to be another day that week, something like that. But that time frame, or a week or so from there, the state was comfortable working with him on deferral of sentencing. So, and the other thing I needed to put on the record, if the defendant is, well, I'll let the court finish up with him.
All right, so.
Then I might have to put something on the record.
Okay. Well, I think I have finished. Mr. Boyd, you've listened to everything that's been said today. Is it your decision to, well, I guess you're asking for more time.
Yes,
Is that what you're asking?
Your Honor, can I just, as a plea to the state, given his situation, I realize the magnitude of the decision, and I realize the spirit of the state in allowing him to have a few days, but I do feel like he's trying to exercise a right to a second opinion, and I certainly would beg the state to allow him, even if it's only a couple of weeks or a month, give him some opportunity, hold the offer open on the 3 years for some duration of time that would give him a reasonable opportunity to try to hire private counsel. I just wanted to advocate for him. Because I gave him confidential analysis. He has a right to disagree and get a second opinion, but if it's not efficacious because the offer's revoked, then it won't really provide any benefit.
All right. So,
Your Honor, I would leave the offer open, but I would like a deadline set and a status date as far as if Mr. Boyd, and I would like that before pretrial, sometime in May, for Mr. Boyd to come back with either an attorney or a decision to keep Mr. Medina. But that court date, I've said it twice now, this was the last day to accept the offer. I'm gonna say it for the third time, if there's no new attorney or if it's Mr. Medina, regardless, the offer's not accept on this next court date that this court sets. The state will, I've got it literally in I just have to press e-file, the amended information. I will be amending it.
how about May 19th?
Your Honor, I'll be out of town.
Oh, okay.
Could it be before that? Is there a date before that?
May 14th. I've got May 14th.
That would be good.
How does that look, sir? Does that give you enough time? That's not quite a month. Does that give you enough time to consult with another attorney?
Yes, ma'am, like about the 20th of May, would that be fine?
Well,
I mean, if it could be early June or something like that, but I'll be out until June 1st. I'll be gone from May 16th to June 1st, I think.
so the options are May 14th or June 11th.
Would the state accept June 11th for a status date for the 3-year offer?
Yes.
Thank you.
Okay, so let me get you a time for June 11th. We've got morning or afternoon. Let me check and see how busy they look. Okay.
Do you need to sit down?
The morning is completely full. I have a 3-hour hearing, so I'm not setting anything else on the morning of June 11th. It would have to be in the afternoon.
Can Your Honor tell us what day of the week the 11th is? I'm sorry.
I believe that's a Thursday.
Okay, that would be good.
I'm almost positive that's a Thursday. It is a Thursday,
Thank
so
you.
that would not interfere with your appointments. So June 11th, and that'll be at 2:30, but let me just tell you that the docket probably won't start at 2:30 because I have to finish arraignments first, and there's no telling how long that might last. I say 2:30, it's an approximate. So 2:30 on June 11th. So that gives you almost 2 months to consult with another attorney and make a decision on how you wish to proceed. And we're also scheduled, I believe, for, well, I mean, we've got pretrial earlier that week. I've just set June 11th. We got pretrial on June 8th. So do we want to just?
The problem is that's on a Monday.
Oh,
and
that's
I hate
right.
that would be a big problem for him. I think it's much better to do 11th and let that serve as his pretrial.
That will serve as Mr. Boyd's pretrial conference as well. So June 11th at 2:30, that'll be your pretrial conference, and the state has agreed to keep their current offer open until then, correct, Ms. Gaynor?
That's correct, Your Honor.
Okay. So there's this motion to dismiss that had to be canceled. It was supposed to be heard last week, but there was an emergency with the state's witness.
And Your Honor, given the defendant's disinclination to have me represent him, I hope that he will quickly retain private counsel if he's able to, and then they would make a decision on how to proceed with a motion of that magnitude.
Okay.
That could really determine a lot in his life. I think he needs to have that second opinion to take that into account. I'd rather not reset it right now.
Okay.
I think we could basically advise, or he and his new lawyer, or me, whatever, we would advise on June 11th on the rescheduling. And if it needed to be rescheduled, go as quickly as possible on that.
Yes.
And, you know, it's possible it could be tried next cycle somehow, doing that in conjunction with trial week or something. I don't know.
Okay. So, Mr. Boyd, do you understand about the motion to dismiss?
Yes, ma'am.
Okay, yeah, it's, in light of your desire to get a different attorney.
It's not denied, right?
No, I just haven't heard it. We were talking about resetting
Okay.
the hearing, but in light of the fact that you've stated you're going to get a different attorney,
Yes, ma'am.
then there's no point in me resetting it with Mr. Medina until you make that decision
Yes,
of whether you're going to stick with Mr. Medina or whether you're going to hire somebody else.
And Your Honor, may I?
Go ahead.
Sorry, Judge. If I have not heard an allegation, and I've certainly not seen a motion in writings asking for a Nelson hearing or otherwise implying that I have not been effective, if defendant believes that I have been ineffective, I would ask that he quickly file a Nelson hearing so we can get that scheduled, because I don't want him thinking that June 11th is just going to begin a Nelson hearing process. This is, with the representation he made, is that he's going to get a private lawyer, but
Right.
I don't want there to be a lingering, if there is any insinuation on his part that I'm ineffective, he needs to file a written motion for a Nelson hearing.
Do you understand that, sir?
Yes, ma'am.
Okay. So, June 11th at 2:30, that's your next court date. If you're going to hire private counsel, do so quickly so that they can get involved and get up to speed on things. Okay? And then they can decide what they're going to do about Mr. Medina's motion to dismiss that he filed. I'll just wait to reset that until you make your decision about which attorney you're going to go forward with. Okay?
Yes, ma'am. Thank you.
Sure. June 11th at 2:30, sir.
All right.
Thank you. All right, is there anyone else here who has a case that's in the courtroom with a case? All right, it is 12:49. We do need to take our lunch break. And we will come back at 1:45 to start on the afternoon. All right, we're in recess.